Yes, Mr. Millett. Now, we're back to Mr. Martin, is that
We
right?
are, Mr. Chairman, yes.
Thank you.
Very
I'll
much.
ask Mr. Martin to come in, please. Good afternoon, Mr. Martin.
Hello, sir.
Welcome back. Are you ready to carry on?
Yes, sir.
Thank you very much. Yes, Mr. Millett.
Thank you, Mr. Chairman. Mr. Martin, good afternoon. We are in the spring of 2013, and I want now to move to your submission to the then Minister Don Foster at CLG 50461. And it's on the screen in front of you. You can see it's dated the 11th of April 2013 from you to Don Foster, copies to the Permanent Secretary's office. Lackland House Inquest, Rule 43 recommendations regarding building regulations. And if we go, please, to paragraph 4 under recommendation, if we can scroll down to see it all. Thank you. It says that you agree to respond to the coroner's recommendations at Annex A, page 3, regarding building regulations as follows. Acknowledge that the guidance in approved document B, fire safety, can be difficult for inexperienced people to apply. Commission a review of guidance given to members of competent person schemes to ensure that there is proper understanding of the scope of the schemes and, where fire protection requirements affect window installations. C. Set out the government's intentions to issue a revised approved document B in 2016 to 17 following a full review of the fire safety aspects of building regulations. This would use the Department's new style guide for easy-to-read approved documents and take account of current research which is due to deliver in 2014. Now, looking at first B, please, for B, can we go to the top of page 3 of the submission, paragraph 12? And you can see there, it says this. Given that most of the issues with building regulations related to the fencer scheme, it would be advisable to raise the issue with fencer and other scheme providers for replacement windows to ensure that their members are fully aware of the scope of the schemes and the requirements applicable to their work. This could be completed in a few months without the need for the Department to divert significant resources. Now, in fact, it's right, isn't it, that the coroner had directed the jury at the inquest that there was no evidence that could lead the jury to conclude that reliance on fencer, the fenestration self-assessment scheme, contributed to the deaths in any way. That's right, isn't it?
I think you're correct. I think the issue that had arisen was that the panels that we were talking about yesterday had been installed by a window installer, and the window installer had self-certified compliance with building regulations through what was then the fencer scheme, and that's one of the different administrative ways of demonstrating compliance. And there then, as I recall, there then followed a debate about whether those panels, which weren't in themselves windows, they weren't transparent, whether they were covered by that scheme or not. And I think within the department, we'd looked at this issue, and there seemed to be I think at the time, Fencer acknowledged that they didn't think those panels were covered by the scheme, and we took the view that a way of addressing the problem that had occurred would be to ensure that Fencer and the other window scheme providers that were in place at the time had a clearly defined scope, so that window installers on those schemes knew whether or not they could self-certify that kind of panel, and if the scheme allowed them to do so, that they had the necessary knowledge and expertise to be able to do that correctly.
Well, you've answered a different question.
I beg your pardon, I thought that was...
I think the answer to my question is yes, isn't it? The question was, do you accept that the coroner had directed the jury that there was no evidence to lead the jury to conclude that reliance on the fencer scheme contributed to the deaths? Do you recall that?
I'm not sure if I recall those exact words. I think, as I said yesterday, I think the general conclusion is that those panels weren't the most significant factor in that fire. As I said, it was a very complex incident, and it would be wrong to regard that incident as a cladding fire. It wasn't.
All right. Let's just put this behind us. Let's go, please, to INQ 3015074. This is the inquest transcript, and this is the coroner's summing up on day 44, 20th of March 2013, after you'd given your evidence. And if we look at line 16, well, we need to go to page 77, please, of that document. If we go to that page, line 16, you can see the coroner gives the following direction. Members of the jury, you need not concern yourselves with questions regarding the fencer scheme, as there is no evidence which could lead you to conclude that reliance on the fencer scheme contributed to the deaths with which we are concerned. I hope that both of those will be of help. So I was simply getting you to confirm that that is correct and coincides with your recollection.
Yes.
Yes. Now, how and on what basis had you, if we then go back to the submission, please, where we were, top of page 3, paragraph 12, how had you, in your submission here, concluded that most of the issues with building regulations related to that competent person scheme?
There'd been a lot of discussion about that issue during the hearings.
But it's not correct, is it, to say that most of the issues with building regulations related to the fencer scheme? That would be inconsistent with the direction to the jury that I've just shown you, wouldn't it?
I disagree.
Why do you disagree?
Because you're talking about the findings of the inquest, not the proceedings of the inquest. The point I'm making here is that this was an important topic, and there was clearly disagreement and misunderstanding on that subject. So it was an issue associated with building regulations that needed to be addressed.
Let's go back to page 2 then, please, and look at paragraphs 4A and 4C of your submissions. So sorry, page 1. I apologise. Page 1. Look at 4A and 4C, where you're summarising for the Minister the recommendations which you had attached. Leaving aside the competent person scheme and looking at 4A and 4C, could you just help us which of those recommendations deals in any way with the coroner's recommendation 1, that approved document be reviewed to ensure that it provides clear guidance on external fire spread?
I think that's A and C.
Where, please?
Well, it doesn't specifically point to those particular recommendations, but in terms of improving the clarity of the guidance, I think that's what A and C are intended to address. Right.
It's not there in terms, as I think you accept. Did you explain separately to Don Foster that the coroner had made 3 distinct recommendations in respect of the approved document?
I can't remember exactly the detail of this submission, but it included a copy of those recommendations, and I would have expected him to have, given the importance of this, he probably would have read them.
Why didn't you set out for him, on the face of your recommendation, that the recommendation number 1 was that the approved document be reviewed to ensure that it provided clear guidance on external fire spread in particular?
Because he would have read them for himself, so they didn't need to repeat them. In the thing with ministerial submissions, as I think a few people have already told you, is that we're expected to keep them very short. So if you're including a copy of the recommendations, which you definitely would do for something like this, you'd expect the minister to read it for himself. You wouldn't want to repeat the text, otherwise you're using up the limited space you've got to say the same thing twice.
Why did you?
And it'd be better that he read it himself.
Right. Why did you summarise the recommendations but omit reference to external fire spread, the one particular thing that the coroner drew attention to specifically in recommendation 1?
I don't think I did that deliberately.
Well, no, but why did you do it?
I think I just answered that question. Is we gave advice to the Minister about what steps we thought was appropriate to take, and gave him a copy of the recommendations so that he could familiarise himself with them.
Was it your general experience, as at April 13, that ministers read everything that was attached to your submissions, or would they go on what was in the submissions themselves, in the main?
That would vary from minister to minister. Something like this, they would read all of it, I would have thought.
And what was your experience of Don Foster's assiduousness when it came to...
My recollection is he was a very thorough minister.
Did you explain to Don Foster that the coroner had made it clear that despite your evidence, both in her Rule 43 letter and during the inquest itself, the simplification of the language and a reshuffle of the layout of approved document B was not going to be sufficient to address her concerns about the clarity of the guidance on external fire spread. Did you explain that to Don Foster?
I don't think so.
Why not?
Again, we need to be very concise with these things, and what we put here was what we thought was appropriate, and a copy of the recommendations was included so that he could consider them.
Did it occur to you that without bringing that fact to his attention, there was a clear risk that Don Foster would not have known that more might be required properly to address the coroner's concerns about clarity?
We didn't think that at the time. As I say, this is a document that I wouldn't have written in isolation, and we all agreed that this was the appropriate advice to give.
Who did you agree that with?
Well, it would have definitely, as you say, I think Mr. Harrell was my line manager then. Mr. Leadsom would have been heavily involved in this, and it would have been cleared by directors and above.
Now, go to paragraph 10. What is said there is this: given the confusion in court, it's unsurprising that the coroner has criticised the clarity of the guidance in approved document B and has called for it to be made clearer. The department has adopted a new style guide for approved documents, which was used in the drafting of new approved documents published in January. Now, just looking at that, you link the coroner's criticism of the clarity of the guidance on external fire spread directly, don't you, to the confusion in court. Why did you do that?
Well, the reason that I'd given evidence at the inquest is because there'd been a lot of confusion in relation to the application of approved document B.
And if you look at paragraph 9, just above that, you say, unfortunately, the expert witness appointed to advise the inquest gave confused and conflicting evidence on what was required by building regulations at the time. This was to some extent due to the process of cross-examination, and it became necessary for me to give evidence to clarify the situation. Now, just looking at that, David Walker, do you remember, was an RACS chartered surveyor instructed by the coroner to advise at the inquest, wasn't he?
Yes.
Yes. Can we agree that he had got confused both during his written and his oral evidence about whether the external wall at Lakanal was required to be fire resisting? That was the subject on which there was confusion.
That was the subject where there was the most disagreement, yes.
Yes.
His report was for the most part correct, and the only issue that he'd not picked up on, which was this issue about needing to look at more than one document to understand what was appropriate for a building of that type. And so it was, that wasn't a fundamental misunderstanding. However, under cross-examination, I can't remember who the counsel was that raised it, but that he was taken through different aspects of the approved document and saying, is this true? What does this say? What does this say? And they got to the end of that and said, and therefore all the external walls, 100% of the external walls need to be 2 hours fire resisting. I don't think there were quite a lot of fire protection people in the room at the time. They all knew that was a nonsense conclusion. But Mr. Walker accepted the argument that had been put to him, I think under the pressure of cross-examination, which was why I was asked to assist the inquest, because it had become a distraction. That it was an argument which had very little to do with the actual incident and was going to swallow up potentially quite a lot of time.
It's right, isn't it, that any confusion on his part during the course of cross-examination didn't explain the views he'd already expressed in his written report, which I think you had told David Crowder in a prior email you thought were wrong anyway. In other words, he'd already made the mistakes or confusions in his...
He'd made one mistake, I think, from recollection,
right.
And that was this issue of whether or not a balcony escape route, you approach it differently depending on whether you can escape in both directions or not.
So was it your position that actually there was no confusion at all about ADB and it was all the fault of the process rather than the fault of the document?
I wouldn't say it was one. It was a mixture of the two things, but I think the process had certainly created a problem, and that's why I was asked at quite short notice to assist the inquest to resolve the particular question that had arisen.
In paragraph 10, as you can see, you refer to the style guide there.
Yes.
In the second sentence, after recording that the coroner had called for ADB to be made clearer. Why do you conflate or identify the recommendation on clarity made by the coroner with the recommendation on language and format by referring to the style guide?
Because the style guide is designed to make the documents easier to read and understand.
It's not designed to make them to clarify matters of substance which are ambiguous or unclear. Yes,
it is.
That was your understanding, was it?
It still is, yes.
Style guide.
Yes, it was an instruction, as well as basic instructions to an editor in terms of layout and so on. We used it as to produce a drafting guide. So in future, we'd approach the drafting of approved documents in a more consistent way to avoid the kind of ambiguities that cropped up over the years.
Right, but that's to be used in the drafting of new approved documents, not as a guide to understanding the existing documents.
Correct, yeah.
Yeah, I see. And therefore a style guide wouldn't allow you, for example, to understand 12.7 in the way you had originally intended it, as opposed to the way in which people in the industry might have been looking at it.
No, I mean, the point I'm making in the statement here is that our intention is to apply this new guide to the approved documents as we revise them so that we improve the quality of them.
Looking at paragraph 11, you say, however, a rewrite of approved document B would be a significant project, and we would therefore recommend this be done as part of a fuller review. The department has not made any statements about when the next review would be carried out, but with Minister's agreement, we've commissioned research intended to feed into a future edition. This work is due to be completed in 2014, and we would expect that a revised approved document could be published during 2016 to 17. Now, I think it's right, isn't it, that the coroner had not in fact recommended a rewrite of approved document, had she?
That's not as I read it.
Well, we can see how you read it, because we can see your recommendations on page 1. Could you go back to this?
I think if you look at all three of her recommendations in relation to approved document B, I'd find it difficult to meet those recommendations without rewriting the whole document. You could meet one of them by only rewriting one section.
Sorry, my question was that the coroner herself had not recommended a rewrite. I think the answer is yes, isn't it?
I think so, yes.
Yes. And what she'd recommended was that the department review ADB to ensure that it provided clear guidance, in particular on external fire spread. Yes? And we can go back to the...
Yeah, no, I accept your point, yes.
Yes. And that was a narrow, focused and pretty specific recommendation, wasn't it?
Yes.
So why had you chosen to read it as requiring a rewrite?
I think because some of the things that she was recommending, approved document B probably didn't achieve.
Right.
So we did look. I'm not sure if we looked at it in that light, but we definitely considered the approved document, considered her recommendations, and concluded that to meet her objective, you would need to rewrite some or all of the approved document.
Did you have a discussion with Don Foster about that? Did you say, for example, well, we can see what her narrow and specific recommendations are at bullet point 1, but actually this is going to require a much bigger exercise, and we should tell her that?
I can't remember for certain whether we spoke to him. I think we may have done, but I can't remember.
Nowhere in this document did you advise that your view was that the provisions of approved document B on external fire spread had already been clarified by the changes made when the document was amended in 2006, do you?
Not directly, no.
Well, and indirectly? Even?
I guess not.
No, why's that?
I can't say for certain. This is something we discussed within the division, and it was looked at up and down the line, and people thought it was an appropriate piece of advice. I can see why, looking back at it, you might argue differently. At the time, we thought it was good advice.
Why didn't you advise the Minister anywhere in this submissions which of the coroner's recommendations he may wish to accept or which those he might wish to reject?
I think we took the view that that wasn't the best way to respond to the coroner's comments. I think, as I said yesterday, if it is considered appropriate that any government response to a coroner should include a direct yes or no, accept or reject line, then I think that needs to be something that's included in formal guidance, which, as far as I'm aware, it isn't.
Well, Mr. Martin, it's really a matter of common sense. I mean, don't you want to be advising your Minister whether or not, on your advice, he or she is accepting the recommendations or rejecting them? Or, if something between the two, identify what it is that they're going to do by way of response. If not, respond in full.
You can argue that. I think at the time we did what I think it was an appropriate response at that time.
Well, the thing isn't the problem here that it isn't crystal clear. You're advising the Minister to weave between the recommendations and the response without making it crystal clear whether they're being accepted, rejected, or adopted only in part. It's mealy-mouthed.
I'm not sure I'd say it was mealy-mouthed. I accept the fact that it doesn't clearly say one way or the other, and none of the people that reviewed this, which is probably best part of 10 people, I imagine, thought that was an issue at the time.
Let's move on in the month to May 2013, and I want to look at the ministerial submission to Lord Pickles, as he now is. Can we please go to CLG 402889? What I'm showing you here is the final collated submission sent to the Secretary of State, Eric Pickles, from Louise Upton in the Fire Safety Policy Team on the 13th of May 2013. And you can see the title, DCLG's response to the Coroner's Rule 43 recommendations. And the recommendation at 3 is that you agree to respond as proposed at Annex B. And then if you move down to paragraph 5 at the foot of the screen, Ministers have agreed recommendations on handling the respective recommendations reflected in the proposed reply as follows. And you can see at the very, very foot of the page, page 1, Annex F, Don Foster submission on building regulation issues. You see that?
Yes.
Now, if you go down to the bottom of page 3 at para 15, we can see that much of the text from your 11th of April submission to Don Foster is set out at paragraph 15 at the bottom of page 3 over onto page 4 at paragraph 16 and 17. Just have a look at that. If we scroll now down to page 4, paragraph 16 and 17, you can see that what's gone in there is very similar to, if not identical, to what was in your 11th of April 2013 submission to Don Foster.
Yes.
Yes. Thank you. Now, there are some differences, and I just want to explore that. First, can you remember, did you draft the final version of paragraphs 15 to 17 for inclusion? We can scroll back to page 3, foot of page 3, look at paragraph 15.
I imagine they were subject to comment by a whole range of people in the department.
Right. Well, let's look at CLG 50559. And there, this is a draft of the ministerial submission from the department. And you can see it's got track changes on it. If we go to page 4, we can see the track changes of paragraphs 15 to 17. There they are in full, building regulations in bold. And then you can see the track changes there, which have come into this document. Did you insert those?
I honestly haven't got a clue. It wouldn't surprise me if a lot of the comments on the drafting came in hard copy form. It wasn't unusual for senior officials to get a hard copy of a document and for them to write their comments on. Yeah. So it could have been anyone that then entered it into the draft.
Right. We have, from the metadata, the 8th of May as the date. maybe that does or doesn't help you with your recollection.
I'm sorry, I haven't got a clue. It wouldn't surprise me if I had half a dozen bits of paper from different people and I was collating that together. I don't know.
The author of the track changes appears to be Martin. Now, that of course could be you. Would it?
Almost certainly would have been me.
Right.
Yes.
And then let's then look at paragraph 17 together. A full review of the approved document would require significant resources and have a disruptive effect on the construction industry. Instead, we propose to seek confirmation from Fencer and other scheme providers for replacement windows to ensure that their members are fully aware of the scope of the schemes and the requirements applicable to their work. Now, quite apart from the fact that the coroner had not recommended a full review of the document, which we've been through already, that second assertion there, that a full review of the approved document would have, quote, a disruptive effect on the construction industry, had not appeared, had it, in your original submission to Don Foster of the 11th of April.
I think you're correct, yes.
Yes, and we can compare the two, but as a matter of documentary. Can you explain why that wording was added?
I'm not sure that I can. It may well be that someone had suggested some extra text. Certainly the government at that time was very focused on, because this was the coalition government following the financial crisis, so ministers were very focused on avoiding anything that might impact on the economy in a negative way.
Yes. I mean, I think that's an answer to my next question, but confirm anyway. Was this extra text intended to ensure that the recommendation received a warm welcome in a deregulating department which was focusing on promoting house building and removing impediments for the construction industry more generally? It
could be. I honestly can't remember. I doubt it was me that added that, but it might have been. Right. It's something we would have spoken about. Certainly, that was one of the if you significantly change a piece of guidance without any intended direct effect, there's still a cost to industry, which would still have registered in the government's sort of one in, one out regime. So that would have been a factor that we were thinking about at the time. I can't remember the exact conversation about this particular text.
When you say cost, is that what you mean by, or was meant by, disruptive effect?
Well, the disruption would be the cost.
Right. Well, what was the evidential basis on which you or others in the department considered that a review of approved document B would have the effect of disrupting the construction industry?
Every review we've ever done, I suppose. It was one of the things that we were required to do whenever we made any changes, whether they were substantive or not, would be to consider what the transitional costs would be. Failure to do that would have fallen foul of the procedures that had been put in place to control regulation under that government. There was an organisation called the Regulatory Policy Committee that reviewed all of this kind of analysis, and they would definitely have rejected anything that didn't recognise that a new pan-industry guidance document was on everybody's desks. That meant lots of people would have to familiarise themselves with the changes.
But I think it's right, as we've seen, that your own initial submission to Don Foster in April, which was attached to this submission as Appendix F, was that any rewrite of the approved document, quotes, should be done as part of a fuller review, unquotes. That's page 2 of the 11th of April 2013. So how are these two pieces of advice consistent? On the one hand, recommending a rewrite as part of a fuller review, on the one hand, and saying that a full review would have a disruptive effect to industry. And instead you're going to have a Fencer exercise.
I think you need. I'm not sure what the other changes are here. It still refers to the fact that we plan to carry out a review of the approved document in the future. As I say, I can't remember who made what changes to this draft. It might have been as a result of the conversations that we'd had with the junior minister.
Well, let me try it differently. Would a fuller review, as you had recommended to the junior minister, have required less resource than simply clarifying the guidance in relation to external fire spread in B4 as the coroner had specifically recommended?
And with the coroner, in our view, the coroner had recommended a review of the whole document.
Well, would a fuller review have had a less disruptive effect on the construction industry than simply clarifying the guidance in relation to external fire spread?
I think you'd have ended up doing 2 pieces of work a year or so apart, each with the same degree of disruption. So that would have registered as, in terms of the 1 in, 1 out procedure, would have registered 2 ins. You'd end up with a greater total cost to business.
Why not just take the coroner's recommendations at face value, word for word, and do what she said? If you'd done that and not had a fuller review, as you'd been recommending, do you accept that that would have required less resource and had much less of a disruptive effect on the construction industry?
Are you suggesting that we could have looked at the approved document and not done anything to it?
Just do what she said.
I don't think any of us took the view that she was suggesting we should review it, satisfy ourselves it's okay and do nothing. I think she felt that something needed doing.
I'm sorry, I'm not really finding that answer very satisfactory.
Maybe I'm confused by your question.
Well, maybe. I mean, we've been through the first bullet point of the coroner's recommendation, which specifically refers to external fire spread. My question is, if you had taken that bullet point at face value, looking at the words on the page, and done what she'd said, do you accept or do you not accept that that would have required less resource and had a less disruptive effect on industry?
I suppose if we ignored the other 2 bullet points, yes.
Now, going back to the submission to the Secretary of State at CLG 402889, please, page 4, paragraph 17. You don't go on, as you did in your submission to Don Foster at Annex F, to recommend that the approved document be rewritten as part of a fuller review. What you say instead at paragraph 17, let's look at it, is that instead you propose to seek confirmation from Fencer and other scheme providers for replacement windows to ensure that their members are fully aware of the scope of the schemes and the requirements applicable to their work. And you go on about that. And then you go on at the end to say that you commissioned research intended to feed into a future edition of approved document B with a publication date of 2016-2017. Do you accept that that advice, taken alongside your earlier advice to Don Foster, forming part of this advice to the Secretary of State, was contradictory, was inconsistent internally, and wholly unclear?
I think the net result is the same. I'm not sure if I follow the point you're making.
Well, the point I'm making is that in the submission to Don Foster, which forms Annex F to the submission to the Secretary of State, you recommended that ADB be rewritten as part of a fuller review. But here in paragraph 17, we're seeing something much narrower and rather different. Do you accept that the advice being given to the Secretary of State was contradictory, internally inconsistent, and thoroughly unclear?
No, I don't think I do.
Why is that?
I think it's quite clear.
Well, which is it? Is there going to be a fuller review by way of a rewrite, or is there going to be a Fencer scheme exercise plus research to feed into a future review or future edition? Which is it?
Well, it says we propose to work with Fencer and the other scheme providers to address the question of the self-certification schemes, and it says that we're planning to revise the approved document and we expect it to be completed in 2016-17. So it's consistent in terms of its outcome. I can't remember why the text has changed, as I imagine lots of different people commented on it before it got to the Secretary of State, and that might be why it's different. But the outcome seems the same to me.
Well, I don't understand that. In the first sentence, you're saying that a full review would require significant resources, and instead you propose to do something different. What I'm simply putting to you is, was that instead, and what follows, instead of a full review, inconsistent with the advice in Annex F that there be a full review?
I didn't read it like that at the time. I think I can see the point you're making. I think, again, it's important to note that attached to this submission, I'm pretty sure, was the letter that the Secretary of State was being asked to sign. And again, the Secretary of State wouldn't have signed that without reading it. In fact, he probably would have asked several people to read it on his behalf as well. So I think the intent was clear. So I'm sorry. I think in total, I don't think that's particularly contradictory. I can see your point. It is a little different. I don't remember why that was at the time. Sometimes too many people comment on these documents and they become unstable. That might have been it. I don't know.
Okay. Paragraph 17, as we can see from the very end, you advise the Secretary of State that the department has also commissioned research intended to feed into a future edition of approved document. This work is due complete in 2015, and we expect a revised approved document B could be published during 2016 and 17. Is it, in other words, is this right? You wanted the Secretary of State to understand that the department would be working towards a revised approved document B with or without the recommendations of the Lacanal coroner?
It might be it's phrased this way because the junior minister had agreed for us to carry out the review, so we didn't need to seek the Secretary of State's permission to do so because the junior minister had already done it. I honestly can't remember. That might explain why it's drafted like this.
Did you intend the minister to think that the proposal to do the future edition of approved document B by 2016-2017 was a response to the coroner's recommendation, or something that the department was going to do anyway?
I can't remember, I'm sorry.
The date 2016-2017, we saw that in your 11th of April ministerial submission to
Yes.
Don Foster. Where did you get that from?
We looked at, so at that time we were working on another project, and we didn't have capacity to start work on approved document B immediately. So we were expecting at that time that we would start work on approved document B as soon as the project we were working on was completed. A project like that can run to best part of 4 years.
Was it your estimate, 2016-2017, or were you given that by somebody else?
We jointly came up with that as being as tying in with the research that we'd already commissioned and how long it takes to do that kind of work.
Right. Now, attached to this submission is the proposed draft of the coroner at Annex B. Now, we don't need to go to the draft. You could take it from me that the draft was cleared without amendment, so we can therefore go to the final as sent version, and that is at CLG 402788, please. And you can see that it was sent on the 20th of May 2013 to the coroner, and I want to look with you at the paragraphs on the building regulations, starting at page 2, at the penultimate paragraph. And it says there, finally, in relation to building regulations, I've noted your concerns about the difficulties that some of those involved in the inquest had with the interpretation of approved document B. I can assure you that my department is committed to a programme of simplification. However, the design of fire protection in buildings is a complex subject and should remain to some extent in the realm of professionals. I'm just pausing there. That's your wording, isn't it? The realm of professionals. We saw that yesterday.
I guess so. As I say, all of this would have been produced cumulatively, and we would have come up with this text amongst ourselves.
Well, did you have a hand in drafting this?
Yes.
Then? You did. Now, a programme of simplification, you can see that in the third line there, was not what the coroner had recommended, was it?
She wanted it to be understood by a wide range of different people. It's pretty difficult to do that without simplifying it.
But as you knew, but I think Lord Pickles didn't, the coroner had specifically commented to you during the hearing that applying plain English principles or having one column on a page rather than two columns on a page would not resolve the difficulties. You may recall we looked at the transcript.
Yes, and I think I've spoken several times now and said that's not all we were planning to do. That's not what the style guide was all about. It was much more involved than that. We put a lot of effort into trying to improve the way that we produce our guidance to make it easier. It's an incredibly difficult thing to do.
Right. And the programme of simplification, did you understand that to be an acceptance of her recommendation for clarification?
Yes.
Going on with the Secretary of State's response to the coroner, on the final paragraph on page 2, please, it says, we've commissioned research which will feed into a future review of this part of the building regulations. We expect this work to form the basis of a formal review leading to the publication of a new edition of the approved document in 2016 to 17. The revision would be drafted in accordance with a new style guide for approved documents aimed at ensuring the guidance is capable of being more easily understood, and that the need to cross-reference is reduced. In the meantime, however, I've commissioned my officials to review the current guidance issued by providers of competent person schemes for window installers. The review is intended to ensure that members of those schemes are fully aware of the scope of these schemes and the fire safety measures which should be addressed, and is, I believe, an appropriate response to the problems that came to light during the inquests. I'm grateful for your recommendations and can assure you of my commitment to ensuring that the safety of residents in high-rise building continues to be a priority. Did you write those paragraphs I've just read to you?
I would have been involved in the drafting of the penultimate one. I doubt I drafted the last one.
Now, you say in your statement, paragraph 29, we don't need to go to it, that no issues were raised with the department's formal response to the Rule 43 letter.
I think the coroner did reply, but not in relation to the building regulations issues.
Right. Now, can we look back then at the department's opening submissions, please, to this module of the inquiry, CLG 3036387, page 33, paragraph 95. Page 32, paragraph 95, thank you. And it says this at the top of the screen: the department's response to the coroner's letter was drafted by officials and approved by and sent under cover of the Secretary of State. The department is of the view that its response to recommendation 4 was not well structured and is unclear and difficult to follow when read against the text of the recommendations. Do you agree with that?
I suppose the point that it's saying when read against the text of the recommendations, I think it doesn't say recommendation 1 accept reject, recommendation 2 accept reject. And if the coroner thought that was appropriate, that the response was inadequate, she could have said so in a reply. As I say, she did take the time to reply to this letter. And at that time, numerous officials and the sort of political leadership of the department had reviewed the letter and was happy that it was appropriate. So that's an opinion of someone looking back at that letter many years later. Do I agree with that? I think it's clear that what the department was planning to do, and if the coroner wanted the department to do something else, she was more than able to say so.
If we go to page 34, please, paragraph. I'm so sorry. Sticking with the same page, paragraph 97. It says this: the advice that was sent to ministers, the Secretary of State's subsequent response to the coroner, failed to articulate clearly that the work was not considered to be safety critical, or to explain how and why this view had been reached. Without this information, the response to the coroner was ambiguous as to whether the recommendation was accepted in full as safety critical, and this may have been the reason why, in turn, the coroner did not challenge or seek to correct any misunderstanding in the department's response. Is there any part of that you disagree with?
I think it was clear enough to the coroner what the department was proposing to do. I'd be surprised if the coroner didn't understand that. As I say, there was a clear timetable in there, so you could look at that and realise that this perhaps wasn't, that we weren't treating this as an urgent piece of work, and I think the coroner would have understood that.
Well, it's right, isn't it, though, that you did not consider, the department did not consider, the coroner's recommended review of the provisions of ADB on external fire spread to ensure clarity to be safety critical.
I think that's probably fair, yes. I think, as I say, we indicated in the letter that this was something that we agreed the approved document could be improved and that we had a programme of work to do so, and set out a clear timetable of when we thought that would be done. And it was plain to anyone looking at the letter that it wasn't being treated urgently.
And would it be fair also to say that you yourself did not consider that any such review needed to be carried out at all as at the spring of 2013?
I'm sorry, can you say that again?
Yes. Is it fair to say that you yourself did not think, as at spring 2013, that any review needed to be carried out at all?
No, that's not true.
So what was it about external fire spread as at April 2013 that you did think needed to be carried out?
No, I considered that approved document B was due a revision. I think approved documents, certainly the more complex ones like approved document B, need to be reviewed probably at least every 5 years.
Yes, that's a generic answer though. My question is a bit more specific.
Well, it is now. It wasn't when you first asked me.
Oh, right.
You asked
Well,
the question you asked me was whether you think I thought at that time approved document B needed review, and I did.
No, you're quite right. Let me be more specific, Mr. Martin. Would it be fair to say that so far as the coroner's recommendations about a review of approved document B on external fire spread are concerned, your view, as at spring 2013, was that no such review is required?
As at that time, we thought that the guidance was adequate, yes.
Yeah, thank you. Now, I'm going to ask you a few questions about the 7 work streams report, which we know were commissioned in 2012, which I think, which was before the Lacknell inquest, and which I think the department had in its hands by February 2015, and which were eventually published in 2019, February 2019. That's what I want to ask you about.
Okay.
All right. Now, can we agree 3 things? Can we agree first, none of the 7 work streams addressed external fire spread and the dangers posed by the use of combustible materials on buildings over 18 metres?
Not directly, but they did address cavity barriers, which is linked to external fire spread.
All right. Can we agree that none of the 7 work streams addressed the clarity of the guidance on external fire spread?
That's correct.
Yeah. Can we agree that none of the 7 work streams addressed the concerns in respect of unusual downwards external fire spread of the type seen at Lacknell House?
I think that's correct too, yes.
Did you appreciate when you read the 7 work streams reports that they nonetheless highlighted a number of areas where ADB was quite significantly out of date and which required prompt action by way of revision?
I definitely knew that approved document B needed work. It was well overdue by the time we'd got to that stage.
I mean, for example, can we agree that Report 7 on the means of escape for disabled people, and we can look at it, included a survey which was highly critical of the adequacy of the means of escape for disabled people?
I think you're correct, yes.
Yeah. And I think you'd known since 2004, which was the time of the 2004 to 2005 consultation on ADB, that the means of escape provisions in ADB was inadequate.
Sorry, you're jumping backwards and forwards in time, and I'm losing track of the question.
Oh, I'm sorry.
We made quite into the 2006 edition included quite a lot of changes in relation to improving standards for means of escape for disabled people. It was very much across the whole of government. There's been it's an area of policy that I guess nearly every policy official in government is trying to wrangle with, is that the population is changing, the demographics changing, and that has an impact on a range of different issues. So we're aware that was something that could be improved on.
Well, let's see if we can approach this slightly more structurally, so as to help you. Let's start with the means of escape for disabled people as Report 7 as part of the 7 work streams. That's at CLG 406270. Now, if you go, please, to page... Well, that's the first page, and it's prepared for you, dated February 2015, yes?
Yes.
And if we go... I'm not going to take you to all of it, but if we go to page 17, we can see the results of a survey there. And there are the question 9 responses. Question 9 is at the top, and it says, within existing buildings where provided, are the means of escape provisions for disabled people suitable and sufficient for the building population? The majority response was no, reflected in the following comments. The first comment is about retrofitting to allow access by disabled people, so hotels, schools, colleges, local authority buildings, to name but a few. And then the second bullet point, no, generally not for buildings where you would expect a higher than normal number of disabled persons to be present. With one evacuation chair, it will take about 30 minutes to get 6 disabled persons out of a typical medium-rise office building. Developers and design and build contractors are only interested generally in doing the absolute minimum to secure building regulations approval, and then maybes, which are there. And you can see the pie chart underneath that at figure 12. So that's what came to you in 2015. But jumping back in time, if I may, to 2004, can we go then to CLG 13062? This is part of the looking forward reporting in 2004, July 2004. Take the date from me. If we go to page, and you can see the heading, looking forward to a new Part B, which I think we looked at earlier on in your evidence. And if we go to page 3 in that document, please, under the heading Means of Escape for Disabled People, at the foot there, you can see it says this. It was clear from the comments made that the current guidance on this issue was inadequate and is an issue that should be addressed. One of the main difficulties concerns how people are assisted from refuges to a final exit. This is generally regarded as a management procedure, but there may be built-in solutions that could facilitate this process, and guidance was required. The use of lifts was thought to be the ideal option. However, it was felt that the potential costs may be prohibitive. In fact, you, I think, got this document at the time. We can see that from, let's go to it, CLG 401526. And that's an email which attaches this document, forwards look, from Peterfield to Mike Payne. And if you go to the foot of the screen, you can see that it goes to Anthony Bird and you, among other people. So can we take it that you saw this at the time, back in 2004?
Yes, I was involved in drafting it, as I recall.
Yes. So, thank you. So did the BRE report in 2015 not highlight to you that ADB needed to be amended to incorporate specific requirements for the evacuation of disabled people, which perhaps the 2006 edition had not done?
Yes, that's why we commissioned it. So the 2006 review, people suggested guidance should be improved, and there was a range of additional measures put into approved document B at that point. I recognised that this would be one of the questions that would arise in a future review of approved document B, and I needed an evidence base so that when we were looking at that question, I would be able to demonstrate why we needed to do more, and that's why we commissioned that piece of work. Yes,
and did that report, when you got it in February 2015, not bring home to you that that work was becoming urgent, given that the inadequacy of means of escape for disabled people had been an issue since 2004?
It's been an issue since long before then. It's as I said before, it's an incredibly difficult issue to address. But yes, it was one of a range of things that we needed to do as needed to address. That will always be the case, I imagine. There'll always be things that you can do to improve things, and it's a case of at each time you review something like this, you establish what's considered to be reasonable at that time, and what's reasonable changes over time.
Right. You tell us in your statement, I don't think we need to go to it, that you also received some research in April 2016 from David Crowder that you'd commissioned in November 2014 to address some concerns raised by the APPG about the appropriate fire performance of cladding panels. Do you remember that?
Oh, this was the question of fire resistance of what often described as spandrel panels.
Well, yes, you cover it in your statement, paragraph 141. We can look at that.
And if you need to.
Well, thank you. Let's do that then, if you want to. Let's go to CLG 3019469, page 50, paragraph 141. Let's go to that, just so we're clear, because I'm not sure I can answer your question. Let's go to paragraph 141, and you can see there you say, in April 2016, I received the results of some research I'd commissioned BRE to undertake on the concerns regarding fire spread over the external walls of multi-storey buildings. I commissioned this research in November 2014 to address the issues that had been raised previously by the APPG in their letter of 5th of August 2014. Yes? That's what you say there.
Yes.
Yes. And you also go on to tell us at 142, I'll read it to you rather than trying to paraphrase it. On the basis of this BRE research, I was satisfied that not only did the building regulations adequately cater for external fire spread, but also that there was adequate guidance available in the public domain. Now, Dr. Crowder has told the inquiry in his evidence that the research was flawed. And he said that in his third witness statement at paragraph 186. And the detailed reasons for that were explored when he gave oral evidence. Let me show you his statement, first of all. BRE 3047668, page 47, paragraph 186. And you can see at the foot of the screen, he says this: I accept the work carried out for the external fire spread reports was flawed. However, the work, I believe, should be seen in the context of the extremely limited resources in terms of budget, time and people that were available to the team to complete it. Now, first, do you yourself accept that the work he carried out, as he says here, for the external fire spread reports was flawed?
It was intended as a scoping study, so it was a small exercise to just examine what the issues were, and there was already some historic research on the same subject, and so it was an opportunity to look at that again, and what I'd hoped is it would be something that we could include in one of a number of journal articles that when we revised this contract in a few years in advance of this time, I'd included a clause in that contract that the contractor would produce journal articles so that there would be an opportunity to disseminate information more quickly. One of the problems we had is that the investigation of real fires work fed into the work that we did, but it might be sometimes 10 years before that got to the industry, where that's too slow. And it's very difficult for us to do something directly because you'd need to go through the political approvals processes.
I'm sorry to interrupt you. Can I please just see if you can answer my question?
Sorry.
Do you agree? All I want to know is whether you agree with Dr. Crowder that his own research was flawed, as he says in his statement.
Not in the context of what it was intended to do.
You don't think it was flawed?
No.
You see, he told us in his oral evidence, day 230, at pages 148 to 220, and I'm going to paraphrase it for obvious reasons, that this was a basic set of experiments using homogeneous materials which were rushed through with extremely limited resources. There were problems with the way the experiments were set up, problems on the face of the report, problems with the fact that the panels hadn't achieved the classifications which were assumed, and problems with the thermocouple measurements in the experiments. That's a very potted version of quite a lot of his evidence, which he's told us. Do you disagree with even the summary I've given you just now?
No, it's the nature of a scoping study is that you carry out some experiments and learn not only about the results of the experiments, but if you were to do a more detailed study, what you'd need to take account of to design an experimental programme.
Where do you get the word scoping study from?
That's the conversation I had with them. This was never intended to be a final answer to a question. It was just what I was trying to say is what I wanted to do was bring into the public domain the historic research on the subject, and also just to show some more recent experiments that we've done. That was what I was trying to do with that piece of work. So I recognised that it wasn't a definitive study. I didn't have the funding to do a definitive study, but by getting that information in the public domain, it allowed people to discuss the facts that were available.
Now, Dr. Crowder told us in his evidence, day 230, page 153, lines 12 to 15, and again at page 186, that you and he had conversations after the Grenfell Tower fire in which you both agreed that his work was flawed. That's what he told us. Do you agree?
Well, that particular piece of work was about fire resistance of spandrels, so it wasn't particularly relevant to Grenfell.
But sorry, do you agree that you and he had conversations after the Grenfell Tower fire in which you and he agreed that the work was flawed?
I don't remember those conversations.
Yeah.
That doesn't mean to say they didn't happen. It was a particularly intense period of time.
He also told us that even at the time research was done, he understood that you wouldn't have had much of an intention of relying on it. That's day 230, page 154, line 13. Is he right about that?
I think so, yeah. I wasn't planning to make that. That wasn't what we'd use to make a fundamental policy decision. It was more about, it was an issue that had been raised by, I think it was Ronnie King had raised it via the all-party parliamentary group. And as I understand it, that had been suggested to him by Sam Webb. And what I wanted to do was to get a broader range of people in the fire safety community to discuss that issue.
But if, as you now tell us, this was never intended to be a final answer, it was not a definitive study, and as you just say, this wasn't what you'd use to make a fundamental policy decision, can you explain why it was that you say, as you do in your statement at para 142, that it was on the basis of this research I was satisfied that not only did the building regulations adequately cater for external fire spread, but also there was adequate guidance available in the public domain?
I think at that time I was thinking about the question of the fire resistance of those panels.
So let's go back. Let's be absolutely clear then, please. Can we go back to your statement at page 50? And you quote from the findings there, yes, there is a clear demonstrable need to ensure that buildings are designed and constructed so that fire spread across the external surface and within the external facade is inhibited, as required by the building regulations. There is adequate guidance available in the public domain to allow this to be achieved. And then you say, on the basis of this BRE research, I was satisfied that not only did the building regulations adequately cater for external fire spread, but also that there was adequate guidance available in the public domain. I put my questions again on the basis of the evidence you've given just now about that research, that it was a scoping study not intended to provide a final answer and not a definitive study. Can you explain why it was that you were satisfied, based on that research, that not only the building regulations adequately catered for external fire spread, but that there was adequate guidance available in the public domain?
I think, from memory, the journal articles covered more than just the question of fire resistance. I think that's the point I'm making here. I don't think I've made it very clearly, and I'm sorry.
Right. Let's move on to a different... Well, before I do, can we agree then, just to put a line under this, that you shouldn't have taken any comfort at all from the piece of work that had been done, and certainly not as the basis for understanding that there was satisfactory guidance in approved document B on external fire spread?
This was a 2016, so I was well aware that we needed to do work on approved document B and was trying to get it done. So I think I think the point I've probably made quite badly here is that this question of the fire resistance was something that I was having. Part of this exercise brought this historic research, which was quite difficult to find, it back into sort of circulation, if you like, and I was happy that it wasn't something that we needed to look at again, but by putting it in that journal article, it provided the opportunity for other people to challenge that.
Mr. Martin, we don't see any reference in paragraphs 141 or 142 to fire resistance as opposed to anything else. It's
I accept that. I think I've not made that clear in my statement.
Why do you say it now? Why do you say that this is really about fire resistance and not about external fire spread, as it says in at least 3 places?
Well, it's the question of fire resistance for those panels related to external fire spread. It's a different facet of external fire spread.
Let's turn to a different topic then. Let's go to CLG 30189330. This is an email chain. I'm so sorry, I shall wait till it comes up. CLG 30189330. Yes, thank you. This is an email chain between Mr. Harrell and you from May 2016. And if we look at the first email in the chain at the bottom of page 1, it's from Richard Harrell on the 25th of May at 10:40 in the morning to you. And over the top of page 2, it says this. You can see from the first few lines of the email that he's suggesting to you that you might like to take on some infractions or EPBD work. And then he says, I would support you on this, as I can understand why the editorial work on Part B turns you off. How long have you been looking at ADB? 11 years? We could export the bulk of editorial work to a technical director through RIBAE, and we should have some money in the piggy bank from Part R if you wanted to free up some time to do this. It's good to do new things to avoid getting stale, and the carbon budget stroke EPPD stuff can be quite interesting. Let me know. As an aside, well, I'll come to that in a moment. Richard, had you told Richard Harrell that the editorial work on Part B turned you off?
I think I'd probably had what you might describe as grumpy conversations with Richard at this time. Because the division had been unable to get clearance to carry out any, or to go out into the public domain with any project work, Richard had decided that what we could do as a team is, amongst ourselves, carry out editorial work on all of the approved documents, which is quite a big. Everybody had maybe 4 approved documents that they were responsible for. I had something in that order, and he wanted us to go through them, apply the new style guide, and produce a draft. I was frustrated by that, because in my view it's very difficult to produce a document that suits its readership if you're not allowed to speak to its readership, and I guess that's where I don't think I was alone in that. I think we were all very frustrated at that time that we couldn't publicly talk about the work we were doing, and I was concerned that I would go through the exercise of doing a lot of editorial work on the approved document, and then we'd show that to our stakeholders, who would all say, no, this is no good, we think this is worse. And so I was unhappy about doing what I saw as work that might not bring any real benefit.
Well, he asks you the question, how long have you been looking at ADB? 11 years. So wasn't this really more about you becoming fed up with the familiar, rather than the frustrations of the editorial exercise itself?
Probably a mixture of the two. I'd been working on ADB a long time. Unfortunately, there was no one else in the team that had any background in fire protection. the one person that we had in the team had left, not least because there was no chance of him getting a pay rise, basically, and he just had a young family, and he could earn considerably more working as a building inspector than he could working in the policy team that wrote the building regulations. So you can see why he left. So there wasn't really anyone else to look at ADB at the time.
Now, looking at the last paragraph of Richard Harrell's email, he says this: as an aside, I've never quite understood what needed to be sorted out in ADB as a result of Lacknell House. Was it primarily application of requirements to retrofit work, or guidance on the surface spread of flame, or perhaps a bit of both? Can you explain why Richard Harrell was so uncertain about that, so out of touch with the coroner's recommendations 3 years on after she'd made them, and 3 years minus 2 months after the Secretary of State's promise?
I mean, this is an informal email between colleagues. He was aware of the recommendations. He probably couldn't remember at that time exactly what they said, I imagine. He'd been... so what was the date of this email? Just trying to place this in time.
The 25th of May 2016.
Yeah, he'd been under an enormous amount of pressure at that time. He was very frustrated, like the rest of us, about the fact that there'd been no progress, and it was making him ill.
Well, he says, I've never quite understood, not I've forgotten. Can you explain why, at least according to him, when you saw this, you thought he'd never understood what needed to be sorted out in ADB?
I think it's a bad choice of words on his part. I think you asked him this question. I can't remember what his answer was.
If we go to your response on page 1, please, second email down, the next day, you say, hi, Richard, it's more like 16 years, but I'm not counting. I'm procrastinating because I'm not able to do the job the way I want to. I suspect I need to lock myself away for a week, and JFDI. I'm getting a bit stale, in quotes. I think it might be a form of midlife crisis. I'm something, is this it? But ADB is almost like my third child. I would gladly have handed the job to Steve Kay, but that wasn't to be. Now, and then you go on to say there's a limit to what RIBAE can do, but I think they could help a lot. What did you mean by I'm procrastinating because I'm not able to do the job the way I want to?
That's the point I was just making, is that Richard wanted us to redraft the document, but we weren't able to do that in the public domain.
I see.
And I saw that as very counterproductive.
And JFDI, does that mean just fucking do it?
Yes.
In what way were you getting a bit stale?
I think I was acknowledging the fact that I'd been working on Part B for a really long time, and I remember when Mr. Kelly was in the team, he had the enthusiasm that I think I had when I'd first joined the team, and I thought, he was a very capable person, and I thought he would be a good person to take over the mantle of ADB and bring some fresh eyes to it.
Right. And why was ADB almost like your third child?
Because I've been working on it for such a long time.
Right. Did you feel like you might have been in the job for too long?
I think at that time I was looking for another job. Yeah, I was fed up.
Right. Was this an acknowledgement on your part in reality that you'd become too close to ADB and were incapable of thinking about it objectively?
I think there was an element of that, yes. I think I did. I had done that job probably too long, and a set of fresh eyes and the enthusiasm that brings might have helped. But as it was, the environment we were working in was not likely to attract anybody with any enthusiasm anyway. What
did Richard Harrell do to help you resolve the difficulties that you have expressed to him here?
I don't think he did. In the end, I JFDI'd it. I got on and I think the next thing I did following this conversation was draft a set of instructions to the editors at RIBAE to restructure the approved document for us. And then I took that as a working draft, which I did some work on myself afterwards.
Richard Harrell told us in his oral evidence that there was some tension, as he put it, between him and you at this time, largely because of him putting pressure on you in relation to the ADB simplification work. That's what he told us, day 243, page 84.
Yeah, I think that's what I was just describing. I mean,
Right.
I mean, we're still friendly. I regard Richard as a friend now. But I think I was getting grumpy with him, and he was probably getting grumpy with me because of the environment we were working in.
Right. What about between you and Bob Ledson? Was there similar tension?
I think there was frustration across the whole division about the situation that we were in at that point. Again, I've got a great deal of respect for Mr. Ledson.
Were you taking short periods of leave at short notice at this time?
I don't know.
Were you looking?
I imagine you're asking me that for a reason. I don't know.
Well, yes. Were you dissatisfied with the department to the point of wanting to leave?
It was certainly something I was considering at the time. If I wasn't going to be able to do the work that I was there to do, perhaps it was time to go and find something else to do. So that was something that I was thinking about, yes.
He told us, did Mr. Harrell, that he'd written his email to you in a deliberately broad way to try to engage you in a broader discussion about whether there were technical changes that were needed to ADB following the Lacanal recommendations. Were you aware at the time that that is what he was seeking to do?
No.
Mr. Chairman, we've got another topic, but I won't finish it within an appropriate time before the break, and I'm conscious that this is probably likely to be a slightly longer afternoon than we're used to. So
Yes.
This would be an appropriate moment.
Yes, well, I think it would. We'll take a break. We'll take a break at that point, Mr. Martin.
Yes, sir.
We'll come back, please, at 25 to 4. And in the meantime, while you're out of the room, please don't talk about your evidence or anything relating to it to anyone.
Yes, sir.
All right? Thank you very much. Thank you very much, Mr. Minute. 25 to 4, please. Would you ask Mr. Martin to come back in, please? Right, Mr. Martin?
Yes, sir.
Carry on. Thank you very much. Yes, Mr.
Thank you, Mr. Chairman. Mr. Martin, can I just revisit one question which we were looking at earlier about the response to the coroner's recommendations, and that was the promise of the review of ADB by 2016-17. And you told us that that timeframe had been discussed collectively within the department. What did you mean, or what did you think was meant by 2016-17?
I think what I meant was sometime during 2016 and 2017. I can't be certain exactly what. That's my recollection of what I remember. It wasn't aimed at the financial year, which I know some people seem to think it was. I'm not sure why we would have done that. The common commencement dates would be the obvious link, but I don't think a project like that's quite difficult to be precise about until you've established the terms of reference.
Right. You say, you know, some people seem to think it was. That includes, of course, Melanie Dawes, the Permanent Secretary of the Department, and I think also Bob Leadsom. Who
apparently so, yes.
Was it your understanding that actually 2016-17 meant at the outside the 31st of December 2017?
I guess conceivably. As I say, it was, as I recall, we felt it was important to indicate an approximate time frame in the response to the coroner. Given that the scale of the project would depend on the terms of reference, which might well change, we gave a generalised date without nailing it down too much, but given an indication of the amount of time we thought it would take.
Right. Does that tell us that in your head, 2016-17 was essentially a 2-year landing spot? It could be January 2016, it could be December 2017.
I think that's what was in my head, but I know you've asked other people that, and they had different ideas, and I think that would have manifested itself when we'd started proper.
Right. So I think we could take it from your evidence that from your perspective there was no shared understanding about what the time frame for the delivery of the ADB review actually was.
Apparently so. I didn't realise that at the time.
A different topic, APPG. I think you will recall, very generally, that the APPG, the All Parliamentary Party Fire Safety and Rescue Group, raised concerns about fire safety and approved Document B a number of times between 2014 and 2017.
Yes.
Yes. And I think you would also agree, just in general terms, that they regularly pressed for updates on ADB review and advocated the greater use of sprinklers, including retrofitting of sprinklers.
Absolutely, yes.
And also concerns about the use of combustible materials and the lack of adequate guidance, as they saw it, on external fire spread. Yes?
I think their focus on external fire spread was the issue that we were talking about earlier, the question of fire resistance. But they had a general concern about modern methods of construction and the increased use of combustible materials within the construction of a wide range of different buildings.
Now, we know that between February 2014 and April 2017, the APPG sent, at our count, 16 or so letters to the department. Not all of those were responded to. Do you agree that not one of those responses replied in any substantive and detailed way to the APPG's detailed and carefully articulated concerns about modern methods of construction, the approved document, and the risk of a major tragedy occurring?
I understand the point you're making. The challenge that I would have drafted many of those replies, probably not all of them. And the problem we would have had is that because we hadn't carried out an exercise to review the approved document and to look at the policy questions they were raising, the government didn't have a policy position on them other than to say, we will look at them when we do the review. And unfortunately, for the reasons which I think the inquiry's only too well aware, that dragged on far too long. But I couldn't say to the Minister, say, we will do this or we won't do that, because the government hadn't made a decision on those points.
You say the government. I think the governments.
I guess it would have been governments, yes.
Now let's go to CLG 402824. This is November 2014. Email run. Picking it up at page 2, please, middle of the page. Email from Anthony Maud, 10th November 2014 to you. You see that? And he says there, Brian, do you have an oven-ready background and line to take on why we don't want a piecemeal approach to ADB, as I think it's something that might possibly be raised with the Minister. And if we go back to page 1, please, third email down in the chain, you can see that you respond and you say, you explain the commitment to the review of ADB after Lacanal, and explain that the research has been commissioned to feed into the future review of the building regulations. And then in the last paragraph on that page, you say this: since then, Stephen Williams has had an exchange of correspondence with the all-party group. Basically, Ronnie King got them to write. These aren't open letters, of course. Over the page, the explanation as to why we won't do this one bit at a time is in the first letter from SW, DR TIFF. And going up the chain, if we can, please, back to page 1, Anthony Maud replies on the 10th of November at 16:32. Thanks, Brian. It is Ronnie who is on about this. And then we see your response at the top of the page, same day, 6 minutes later, 4 minutes later. Yes, he's very annoying. Basically, we will not be changing the AD as and when Ronnie asks. We'll do it when we're ready. Every time we change the AD, there's a transitional cost to industry, so we don't want to do too many piecemeal changes. He's miffed that we made some deregulatory changes in 2013, so why can't we do a quick change to the AD now and require sprinklers wherever they can go? Ronnie will not listen to reason, so I just ignore him. Why was he very annoying, Ronnie King?
It's the nature of, so Mr. King's a passionate campaigner for fire safety, and was involved both in the Fire Sector Federation and was the secretary for the all-party parliamentary group. All-party groups are groups of backbenchers whose function is to press the government on the issue that particular group's interested in. So their function is to be annoying. Their function is to harass the government and press the government to do things that they think should be done. So arguably that's kind of the point of them.
Was he annoying because he was pressing you to do things that you didn't think should be done?
No, I think, when was this dated? 2014? No, I wanted to review approved document B, but obviously that's not something that we would have been able to directly say to him. But he was pressing the department to change the building regulations immediately, and that wasn't something we were going to be able to do.
But is the truth that he was advocating for fire safety standards which you had decided were over the top and unnecessary?
He advocated some standards which would not have met with the government's regulatory policy.
Is that what made him annoying?
Not so much that he was advocating those things. I think as the point here, as I say, Mr. King's a passionate advocate for fire safety, and I think during the period that I've been working in the department, I think the APPG with Mr. King have met practically every minister I've served in that time, and he had a tendency to argue in a way which probably put ministers off the subject, and I used to find that frustrating.
Wasn't it important, though, for you to engage with stakeholders who might be advocating for significant improvements in fire safety, particularly in residential buildings?
Yes, and we did.
Well, why did you think it was annoying then, if he was doing exactly that?
Because the way he did it was annoying. Doesn't mean to say we didn't engage with him.
Why was it acceptable just to ignore him?
This is an informal email between colleagues. We didn't ignore him, and most of the time he was writing letters on behalf of the all-party parliamentary group, so those were letters that would be replied to by a minister.
Do you agree, looking back on it now, that the concerns of the APPG were met by you, and certainly by the department where you weren't writing the letters, with unjustified hostility and derision?
No.
You don't accept that? You don't accept that at all?
No.
So is it your view that you entertained the APPG's concerns fully, candidly, and with full attention to the detail that they were?
Insofar as was possible, given the constraints that we worked within, yes.
Do you remember?
As I say, I think a minister met with every minister I served, and the ministers came. I think over that period, I think we were lucky to have a minister that lasted a year, and each one of them met with the all-party parliamentary group, and invariably they would exchange pleasantries and then hand over to Mr. King, who would directly speak to the minister. So I think he probably spoke to ministers more often than I did.
Do you remember going to an APPG lunch with Sir David Amis and the Minister James Wharton at the House of Lords on the 26th of November 2015?
Yes, I think that the APPG often invited a new minister to attend a lunch. I think it was a way of getting it's a tactic for getting into a minister's diary. Usually the only slot that's free is the lunch break, I think, and so they would invite the minister to lunch and then lobby him on issues that they were concerned about.
You say lobby him. Let's see what happens on this one. You remember it. CLG 1008066. Now this is a note of this meeting. And there it is. Have you ever seen this note before?
I wrote a note of this meeting. I don't know if this is the one I wrote.
Oh, right. That's helpful. Have a look at it and let's see if you can help us to see whether it was you who was the author. It refers to the lunch meeting, 26th November 2015. It identifies those present. You can see Sir David Amis, MP, chairman of the APPG, invited James Wharton MP to an informal lunch with some members of the group and Brian Robinson, chairman of the Fire Sector Federation. The meeting took place on Thursday, 26th November 2015, between 12 p.m. to 1 p.m. in the Barry Room, House of Lords. And you can see who was in attendance: Sir David Amis, MP, and a series of other MPs, Ronnie King, OBE, and a number of others, and you, and Sarah Morgan from the DCLG. Does that help you?
I remember the meeting.
You remember the meeting?
Yes.
And then it starts. Sir David Amis MP, chairman of the all-party group, introduced the group and flagged that they had not been able to persuade previous ministers that a review of approved document B was urgent. Brian Robinson then sets his concerns out, and then after some contributions from others at the meeting, we can see that the minister said in the pre-penultimate paragraph at the bottom, James Wharton MP said he did not want to do work. He did not want to do work with the building regulations and hoped to. He did want to do work with the building regulations and he'd hoped to set out his plans early in the new year. He welcomed comments from the all-party group and the Federation. However, he was clear that the principal objective for any work would be simplification and the reduction of red tape. He raised a concern that a debate on a significant change in scope for Part B beyond life safety could significantly delay progress and should be raised as a separate issue. Now, did that option, prioritising the review on life safety issues, get picked up as an option with the department?
So Part B is restricted to life safety. I think one of the issues that we did pick up in the discussion document actually was whether it should go beyond life safety to property protection, particularly in domestic buildings. So I guess we didn't pick up on that as a way of accelerating things. I think in practice it wouldn't have made a lot of difference.
Did you say anything at this meeting?
I don't think I did. I think I did write this note, by the way. I'm pretty sure I recognise it. The way these things normally work is is you provide some advice to the minister about the general background to the issues they raised, and you sit quietly unless the minister asks you to explain something.
Right.
And I'm pretty sure I'm pretty sure I sat there and said nothing throughout that meeting. I distinctly remember James Wharton raising the simplification issue. He was fairly new in the job, I think, at that stage, and I imagine that's probably something that had been brought to his attention by either the Secretary of State or the Prime Minister.
Now, you say you didn't say anything. Does that tell us that you didn't mention the fact that there was widespread ignorance about the use of combustible insulation in the industry above 18 metres, which meant that there were potentially many blocks out there with combustible insulation on them?
In a meeting like this, an official keeps quiet unless he's asked to say something.
Even on a matter of widespread risk to life safety?
Yes.
So protocol before lives?
I wouldn't have thought about it that way, but the protocol is that this is a meeting between the all-party group, which is mostly MPs. There are a couple. There's at least one lobbyist in the group as well, and the minister, and that conversation pans out, and then it's for the minister if he wants any further briefing after the meeting.
Well, why not raise it with the minister quietly, separately?
I think he left straight away to do something else. I mean, we don't get that much airtime with ministers. I'm a junior official, so it's not as if I have the opportunity for regular conversations with ministers.
Does that explain why you didn't mention also the fact that there were parts of ADB dealing with the fire safety of cladding panels and insulation, which were regarded by much of the industry as unclear and in need of clarification?
I could have sat there for a couple of hours talking about the different things that needed to be improved, I imagine, but that wouldn't have been acceptable. The minister would have shot straight off to the next meeting.
Or that people had flagged the presence of ACM with a combustible core and asked whether the awesomely powerful fire that had occurred in the UAE...
Same answer. That's not something I would have had the opportunity to do.
Well, I'm going to get to the end of my question.
I beg your pardon.
And then you can answer. That's how this works. Does that also explain that people had flagged the presence of aluminium composite material with a combustible core as present and asked whether the awesome power of these fires in the UAE could happen here? That was something you knew. Does what you told us explain why you didn't mention that to the minister?
Yeah, all I wanted to do at that stage was get moving on the next review so that I could address a wide range of different issues which had arisen at that point. But that's not a conversation you have in that kind of environment.
I'm now going to turn to some questions about the period immediately following the fire. Now, the first question is, when did you first come to realise that Grenfell Tower had been clad in aluminium composite material panels with a polyethylene core?
I think that information became clear quite early, within a day or so, I think. I'm not sure how, but it seemed to be an accepted piece of information.
Now, during the course of your evidence, you've told us a number of times, Mr. Martin, that you underestimated the scale and hazard of the issues which had been raised with you about the use of ACM PE products on high-rise buildings in the UK.
Yes.
When did you first come to the realisation that you had underestimated the scale and hazard presented by those products?
Probably around the time of that fire. I think I remember being horrified by it.
Can we then look at NHB 401457? This is an email from you to Diane Marshall of the NHBC on the 16th of June 2017 at 14:36 in the afternoon. So this is a day and a half after the fire. Forward rebuttal of Times article, importance high, and you say this: apologies in advance for asking, but I've been asked to prepare a rebuttal of the assertion that PE cord aluminium composite panels comply with the guidance in ADB. I have also been asked if an independent expert would be willing to say this or something similar in public. Can you consider the attached and let me know, please? Now, let's look at the attachment. It's at NHB 401458. And it reads as follows. In the Times, and it says, the Times asserts that cladding on the Grenfell Tower was formed using a composite aluminium panel with a polyethylene core. It claims that such panels conform to UK standards but are prohibited in other countries. We cannot comment on what has or has not been used on Grenfell Tower, but we would dispute the assertion that a polyethylene cored panel is acceptable for use under current building regulations. Requirement B4 of the Building Regulations 2010 provides that, quotes, the external walls of the building shall adequately resist the spread of fire over the walls and from one building to another, close quotes. Paragraph 12.5. The guidance in approved document B that supports this requirement says that the external envelope of a building should not provide a medium for fire spread. It goes on to provide detailed advice that, quotes, in a building with a story over 18 metres or more above ground level, any insulation product, filler material, not including gaskets, sealants and similar, etc., used in the external wall construction should be of limited combustibility. Paragraph 12.7. Unmodified polyethylene would not meet the definition of limited combustibility. So a composite panel formed with a polyester core would not be considered to comply with this guidance. As such, it should not be used as a cladding material on buildings over 18 metres in height. Now, before we look at the detail of that text, I'd like to look together with you at Diane Marshall's response to you, which is a little bit later that same afternoon. Can we please go back to NHB 401459 and look at the top of that document? She says, hi Brian, thanks for the email. Whilst I fully agree with the content of your suggested text, I believe it may be seen to be more independent by engaging with the BCA as the broader body representing all BCBs. The current chairman is Martin Conlon, who has already been involved in some media coverage, so I would imagine be happy to support you. His email address is, and then it's provided. Now, having received that rejection from Diane Marshall, can we then go to CLG 3036408? And her email comes to you at 1528. And if you look at the last email on the first page here, at 16:32, so 4 minutes later, you write to your former colleagues Debbie Smith, David Crowder and Sarah Colwell in identical terms. Do you see that?
Yes.
Yes. Now, let's look back at the text at NHB 401458, which I've just read aloud to you. There it is again. Who drafted that?
I guess I did.
You did?
I believe so, yes.
Now, the content of that draft rebuttal is in line, isn't it, with the text of your earlier note to Melanie Dawes' office sent on that morning, 16th of June 2017, which we looked at, where you effectively explained that the use of non-fire retardant ACM panels would be in contravention of building regulation guidance and is effectively banned. Do you remember we looked at that document? Yes. And we can look at it again if you'd like, to be clear, but no. I'm putting to you that the content of this article that you drafted was consistent with what you told Ms. Dawes that morning.
Yes.
Yes. Now, if we look at the final paragraph in your draft rebuttal here, you say, or rather you refer to unmodified polyethylene. Why do you do that? Why do you refer to unmodified polyethylene?
I'm using that to describe polyethylene, an ACM core that has no mineral content in it, and so it's just polythene. It hasn't got any fire retardant in it.
Right. Was it your view at the time that a polyethylene core modified with mineral content necessarily be a material of limited combustibility?
I think at that time I probably didn't know. I think I was talking specifically about, and I'm not sure why we were talking about unmodified polyethylene at that time. It might be that that's what had been asserted.
Right.
I might need to look at the Times article to see what they said. I'm not sure that's necessary, though.
Did you have any knowledge about what quantity of mineral content was required in a polyethylene core to permit it to be classified as of limited combustibility?
No, not at that time,
You
no.
didn't. Right. Why was it possible, after the deaths of 71 people on the night, to state so definitively that such products were not acceptable for use over 18 metres, when you'd been asked that repeatedly for a number of years and had never given any plain and unequivocal view to that effect?
I think that is the answer that I'd given in the past. Not phrased in those. That's the point that had come up repeatedly. I wasn't saying anything new.
Well, the closest you'd ever come, and you'll recall this from our questions and answers before, but the closest you'd ever come to an unequivocal view was that the polyethylene core of such products could reasonably be considered to be filler material, which is what you told Nick Jenkins in February 2016.
Oh, I see what you're saying.
Yes. So why were you able to be quite so definitive in your response to the public in this way, that you were intending somebody should say, if not you, but hadn't been unequivocal like that in your response to Nick Jenkins?
It's probably because that's probably what the press office would have wanted me to do. There may have been some iterations of this where I'd been bouncing it with working with the press office.
Why did you consider it necessary to provide Diane Marshall, and then, after she'd said no, Doctors Smith, Crowder and Colwell, with a pre-prepared script, rather than simply asking them to express their own independent views as independent fire safety or industry experts?
As I recall, somebody senior in the press office instructed me to draft a rebuttal, and at the same time I was told to find an expert that would support the department's position. I think at the time I had doubts that anyone would be willing to do that, not necessarily because they disagreed, but just because immediately after an incident like that, people will be very cautious about getting involved in any public domain statements. So I did it. I was told and sent a draft form of words to a range of people that I thought would do what I'd been asked to do. It didn't surprise me that in the end, I don't think any of them actually agreed to say something publicly, although several of them accepted that, agreed with the points that was in the note.
You say in that last answer that somebody senior in the press office instructed me to draft a rebuttal. So did the instruction to draft this text here not come from your line manager, Richard Harrell, or Bob Leadsom?
It might have done, but it would have come from the press office. And I have a recollection that this was a really intense period, ultimately, certainly the idea of getting an expert to support the department would be something that came from the press office, I'm sure of it.
Right. Did you query that, either in your own mind or with the press office, to say, well, we're the government, whatever we say is the government's position, we don't need an independent expert to support it?
Press handling strategy is what press officers do.
But my question is, did you challenge it as something?
I think I may well have told them that I'd be surprised if anyone's willing to make a public statement about anything so quickly after the fire. My experience is that the people that do make technical statements immediately after incidents like this tend not to be the most reliable experts.
I mean, if the position was as crystal clear from ADB as this text says or indicates, why not just let NHBC or BRE express their own views in their own way?
I guess this is quicker. And as I say, the press handling is something that the press office and special advisors and ministers are more interested in.
Right.
So you get told to do something like that, you get on and do it. So I'm a junior official, that's what you do.
Did you consider it appropriate to approach these organisations with a finished, pre-prepared script to be presented as if it were the independent view of an independent expert in support of the government's interpretation of the guidance after the fire?
It's not something I'd ever been asked to do before. I understand it's not that unusual.
But did you consider it appropriate?
I thought it was a bit odd, but I didn't think it was inappropriate.
Right. So you thought it was a bit odd. Diane Marshall told us that she considered it to be a bit unusual, and Dr. Smith considered it to be inappropriate. I think is this fair? You're somewhere perhaps between the two.
I guess so, yes.
Right.
I've spent a lot of time working with press officers and the press, so perhaps I'm more used to that kind of stuff.
I mean, did you go along with this as far as you could because you knew the fragility of the position the government was in?
Oh, I don't think I was thinking about that at the time. I think I didn't know which way was up, I think, those few days after the fire.
So far as you could tell from the press office or the department more generally, was the department seeking to bolster a retrospective recasting of the narrative with apparently independent support?
I don't think so. I remember quite shortly after all of this that I'm not sure which it might have been the permanent secretary or somebody quite senior in the department commissioned legal advice to satisfy themselves that the position that I set out here was one that the department was happy to continue with. So they didn't accept my word as being all necessarily correct. They checked it with they sought council's opinion, I think.
Going back to the emails, please, at CLG 3036408, we can see that Debbie Smith responds to you within the same minute, and she says, "Hi, Brian, just spoken to David. It's my understanding that this is no longer live. If this is wrong and or you need to discuss, please let me know." And then if you go, please, to the second email in the chain, up, please, you say to her, 2 minutes later, "Hi, Debbie, I still need an expert, but it can't be an employee of BRE. That's the approach I agreed with the Met Police. See you in the morning." Why could it not be an employee of the BRE?
I think, bearing in mind it says a discussion with the Met Police, I think by then the Met may have already appointed BRE as advisors to the investigation, and so they probably wouldn't have wanted BRE to get involved in any public comment.
Right. And we can see at the top of the screen, "Brian, can I call you or you call me? I'm on the Eurostar, so maybe patchy coverage." Did you actually speak to Debbie Smith at that time in advance of the meeting of experts to take place the next day?
I honestly haven't got a clue. I might have done, probably not.
Let's then go to CLG 403356. Now, this is a chain of emails internally between you and various officials at the department on the morning of the 16th of June, so earlier the same day. And if we look at the third email down in the chain, we can see an email from you on the 16th of June 2017 at 11:47 to Office of Melanie Dawes, Helen McNamara, Sally Randall, copy to the Grenfell Tower team and Shane Coulson, urgent expert advice. And you say, "I've been asked for a draft cast list for the urgent meeting of experts. Most have confirmed availability. Currently as follows." And then you go on to list the cast members. You've got Debbie Smith, Colin Todd, Professor Bisbee, Sir Ken Knight, Roy Wilshire, Dan Daly, Dr. Crowder, and others or officials from the Home Office and DCLG. Yes?
Yes.
I think I missed out Martin Shipp.
You did.
I'm afraid. Did you select those names?
I certainly suggested some of them, probably most of them, but not, I don't think all of them.
Right. Do you know whose names you didn't select?
I can't remember.
Is it right, to the best of your recollection, that the purpose of gathering that group was to provide immediate advice to government on various aspects of this tragedy, and particular on steps to be taken in terms of safety checks on other buildings.
Yes.
A meeting of that group took place, didn't it, on the next day, Saturday the 17th of June?
Yes.
And it happened at Marsham Street, I think, didn't it?
That's correct.
Yes. Can we go to CLG 405247? This is a document, a briefing note, setting out information for the Minister, Alok Sharma MP, as the chair. He was by then the Secretary of State, wasn't he, for DCLG?
No, he's Minister of State.
The Minister of State. And if you look at the first page, you can see there is Debbie Smith and her bio. And if you go to page 3, we can see that you were to attend, along with Bob Leadsom and Louise Upton. Yes?
Yes.
And if we go to page 4, we can see the purpose of the meeting. And it says, we've called together the group of fire safety experts to advise us on advice for local authorities and housing associations on how to identify risks in similar high-rise buildings, risks which have been refurbished with cladding, and the process for assessing those risks and taking necessary action to provide reassurance for tenants. Does that align with your understanding of the purpose of the meeting?
Yes, I think so, yes.
If we go lower down page 4, you can see that it says handling. We suggest that you open the meeting by thanking them for their help and outlining the government's expectations and plans for helping provide tenants of similar buildings with reassurance about the safety of those buildings. Suggested opening remarks at Annex A. Then invite Brian Martin, DCLG Buildings Regulation Fire Safety Expert, to lead the discussion. Why was it you, did you understand at the time, who was singled out as the fire safety expert among all these people to lead the discussion?
Well, I was the DCLG. There wasn't anybody else at DCLG that worked on fire safety, and I was just opening the discussion.
Well, you're going to lead it.
I think you're reading too much into that word. I think I just set out what we were trying to do, and I mean those people aren't the sort of people you can tell what to say. That they're quite capable of expressing their own opinions.
Yes, I'm not. This isn't about.
I'm sorry, I don't understand what you mean by what you're remarking on lead the discussions. I don't understand.
Well, I'm asking you what you understood by your role as leader of the discussions.
To set out what the department was hoping to achieve by the meeting, and seek the advice of the people that attended.
Did you lead the discussion in that way?
I certainly started the discussion. As I say, that none of these people are sort of retiring, and quiet types. They all had plenty to say.
Let's go to page 5, where we can see some further details set out for the Minister in a speaking note. And under the second heading, purpose of the meeting, you can start at the 4th bullet point down, which says, we are asking for your advice on how local authorities and housing associations can identify risks in similar high-rise buildings which have been refurbished with cladding, and the process for assessing those risks and taking necessary action. Please provide your frank advice to me and my officials. We really need to know what you think we should be doing. Clearly, as we go forward, we will need to be very careful about saying or doing anything which could cut across the investigation, but at this point, we need your frank advice. Was it clear to you during this meeting that the Minister was asking for your full and frank advice, as well as that of the others?
The Minister never said any of this in the end, as I recall. I think he was called away to a Cobra meeting, and I think he came into the room, thanked everybody for coming, and left without really saying any of this.
Right. I see. Did you not see this note at the time?
Yeah, so a note like this is so this was organised at very short notice, and Minister's private office would have asked for a standard briefing. A standard briefing includes things the Minister might wish to say. Whether the Minister says it or not is a matter for the Minister. And my recollection of this meeting is that he was there for maybe 2 minutes before he was... and he essentially popped in to thank everybody for coming and then shot off to a meeting with Cobra.
I follow. Let me see if I can get it in a slightly different way. Did you draft this note?
I don't think I did, no.
So there are two parts to it. So the technical expert group, next steps, with all the photographs and biogs in it, and then the handling brief. Do you know who drafted those two documents, if they are indeed separate?
We dragged a few people in from other parts of the team to organise this. Might have been Mr. Leadsom. I honestly don't know.
Whether the Minister said it or not, was it not your understanding, at least, that the Minister was relying upon everybody there, including you, to give him full and frank advice?
I suppose so, yes.
Yes. Now, if we go to the very bottom of page 5, we can see that it says, invite Brian Martin to say a little more about some of our initial thoughts on this and leads the discussion. And if we go to the next page, page 6, please, in the top paragraph under possible questions, it says this: do you think this is an isolated incident or something peculiar to this building? Recognise the need to be very careful about speculation and comment, given that there is a criminal investigation underway. Do you remember whether there was any discussion on that topic?
I think so.
Do you remember what advice or answers were given to the question, is this an isolated incident or something peculiar to this building?
I can't remember in detail now.
Did you, or to your recollection anybody else, including perhaps Dr. Smith, tell the Minister that the department had carried out a full-scale test on a cladding system incorporating ACM panels some 16 years previously, and therefore had a very good idea of how such panels were likely to perform in a fire?
Well, the Minister wasn't there, but no, that didn't come up in conversation as I recall.
Can we just clarify something? You've told us that the Minister attended for about 2 minutes and then disappeared.
Yes, and there's no criticism of him, sir.
No, I'm not suggesting it was. What I'd like to understand is who chaired the meeting?
I'm not sure if we had a formal chair. Arguably, it might have been me, sir. It wasn't that formal a gathering.
All right, and do you know who at the meeting had a copy of this briefing document?
I would have had access to it. I'm not sure if I had it in my hand at the time, sir.
And Mr. Leadsom and others from the department?
They might have done. I imagine Mr. Leadsom might have had it in his hand, actually. I can't remember for certain, sir.
And would I be right in assuming that those who were not officials, in other words, the various persons attending whom we see with their pictures, did not have a copy?
That would be correct, sir, yes.
Right. Thank you very much. Yes.
Now, you say the Minister attended for about 2 minutes and then had to rush off to a Cobra meeting. What happened after that? Did the meeting break up, or did you all carry on?
Oh no, we discussed a range of things, whether so I think there was a discussion about the different types of ACM that was available, And the question arose about how do you differentiate between those. So the key question we were trying to address at that time was, what can we say to building owners so that they can identify if they've got similar material on their building? And the challenge there is that there were, at that time we understood to be 3 types of ACM, and it was difficult to tell which type it was just by looking at it. So I think it was Professor Bisbee and Dr. Smith that agreed to see if they could come up with a useful way of identifying the type of ACM that was on a building. And there was and I think having been through that exercise, there was a discussion then about, okay, so what should a building owner do if they find that they have got the similar cladding on their building? What's an appropriate response to that? And I think, again, several of the people in the group sat down and came up with draft advice to building owners along those lines.
Was there any discussion at the meeting, whether or not the Minister was there, that as a result of ACM with PE cord panels to achieve class 0, those panels would have been perfectly compliant with the guidance in approved document B, at the very least until the publication of the 2006 edition in April 2007?
No, that's not the way. The main focus of this debate was, how do we find buildings with this type of material on them, and what advice do we give to building owners if they find they've got it? That's it. It was all about what to do now. There was very little retrospective discussion.
Well, the question, you see, the reason I'm asking you this is because in the speaking note, one of the things that it was thought that would be of interest to the Minister was whether this was an isolated incident or not. As you can see from the possible questions on your screen, do I take it that that question simply wasn't investigated at this meeting?
I suppose the point was we needed to find out, and the way to be sure would be to ask building owners to check that what's on their buildings and provide a means for identifying it.
Mr. Martin, you knew the answer to this question, though, didn't you? You'd been given it by Nick Jenkins in the February of the previous year, 2016. And indeed, you would have known this because it was only in 2007, to your way of thinking, that the introduction of the word filler in 12.7 put an end to the use of combustible cord panels.
Well, I think Mr. Jenkins said that all the material he supplied was fire retardant. And he alleged that other buildings might have the polyethylene cord ACM. But in answer to the question how many of those there were, I didn't know.
Well, let me try it slightly differently. We can argue till the cows come home about what Mr. Jenkins actually said. Did you tell anybody present, or did you take any steps to get the Minister to know that there was a matter of grave concern, at least in some sectors of the industry, caused by the widespread use of ACM panels with a polyethylene core in the UK?
I didn't mention the discussions we'd had about interpretation of the approved document at this meeting, as I recall.
But why not, given that that would have answered the question, is this an isolated incident?
Well, we're working on the basis that that if there's one building, there are probably others. So I think we took it as read that there probably are others and we should find them. As I say, we were focused on trying to find other buildings with a similar cladding systems and what advice we could give to building owners to ensure that people in their buildings were safe.
Yes, I understand that. But there's the question here, which somebody thought fit to put in as a potential question to have answered. Did you, when you saw this document, think of taking steps in all candour to tell this group and, through some route, the Minister, that the Grenfell problem was unlikely to be an isolated incident because you had been aware a year earlier by Nick Jenkins of Boothmury of the fact of historical and ongoing widespread supply and use of ACM PE for high-rise residential buildings in the UK?
I didn't raise it at this meeting, no.
Why is that?
I didn't think it was helpful.
Well, it may not have been. Why wouldn't it have been helpful?
The net result was the same. We needed to work out what to tell building owners to know what to do next.
Let's go to the minutes of a meeting on the 17th of June.
I'm sorry to interrupt you yet again, Mr. Millett, but can you just help me with one other aspect of this meeting? The speaking notes and so on obviously assume that the minister would be there and would ask these sort of questions and obtain advice from the people at the meeting. Now, in his absence, who, if anyone, was seeking advice on behalf of the department or on behalf of the minister from those present?
It would have been either myself or Mr. Ledson, I guess. I wish I could remember the details, sir. I'm sorry.
All right, I see that Mr. O'Connor was there, or at least he's said to have been there. Was he a more senior official?
He's a director, sir, yeah. I think he attended... Did he attend the whole meeting? I can't... I wouldn't want to say that. Now you mention it, I think he was there, but I don't know whether he was there for the whole meeting, sir.
Yeah. And as you understand it, who, other than perhaps yourself or Mr. Ledson, was, as it were, collecting the advice?
I guess it was us as officials, sir, yes.
All right. Thank you very much. Yes, Mr. Millett.
Can we now go to CLP 3016581? This is the minute of a meeting of the 17th of June, Saturday, at noon, in the Ministerial Conference Room in Marsham Street, with Alok Sharma in the chair, present as Minister of State. Also present, Debbie Smith, Colin Todd, Luke Bisbee, Ken Knight, Martin Shipp, Roy Wilshire, Nick Coombe, and DCLG officials. Let's go to the minutes, please, at page 1, final paragraph. Summary, and this is under the summary of discussion. Last bullet point. From the available information, it was understood that a PE called Aluminium composite material, ACM cladding system, had been used on Grenfell Tower. While the exact reasons for the speed of spread of fire have yet to be determined, it was agreed that additional tests should be undertaken with regard to this type of cladding. Did you, during that discussion, or at any other time during this meeting, tell the minister or anyone present that you and the others, or some others present from the BRE, including Debbie Smith, might have a very good idea as to the exact reasons for the speed of spread of fire, namely the result of the 2001 testing?
I don't think there was any... we were working on the basis it was probably the cladding, but I think the way... I don't remember who drafted this note. I think it was clear that from the pictures and that we'd all seen that the cladding had been an obvious factor in the fire, and I think it's phrased in that way just because you can't be absolutely certain until an investigation is complete exactly what happened.
No, but my question again, did you or anybody else from the BRE tell those present that you and the BRE might have a very good idea as to the exact reasons for the speed of the spread of the fire? Namely, what you'd learnt from the 2001 tests.
Well, I certainly understood the way that ACM, the mechanism by which ACM ignites. And I think we may have discussed that.
Did you tell the minister that you or others within the department were aware of and that you had been remarking on the awesome power of major fires involving external fire spread through ACM PE products internationally since 2012?
I think certainly the fact that ACM had been involved in fires in other countries was something that we talked about.
You did. Did you tell the minister that you'd been assuring others within the department that your view, whilst there were no guarantees, was that such a fire should not happen in the UK on the basis of the content of approved document B?
No.
Why not?
that wasn't necessary at the time. All we were focused on was about what we could do to address the problem that was in front of us.
Did you tell the Minister or anybody else at the meeting that the only specific and targeted guidance in approved document B which would serve to prevent the use of ACM polyethylene cord panels on high-rise buildings in this country was the words filler, material, etc. in 12.7?
As I say, that was something that was discussed at some point quite early on in the department's response to this disaster. And the department asked for council's opinion to check against the view that we'd taken.
Did you tell those present that the meaning of the word filler, material, etc. had been the subject of heated debate and a difference of interpretation for a number of years?
I'm not sure it was heated debate. I think
All right,
it
debate.
been discussed.
All right, debate.
Discussed.
Debate and difference of interpretation for a number of years.
I don't think I did at the time.
Why is that?
It didn't seem important at the time.
Right. Did you tell the Minister or those present that that particular language had been introduced into the approved document by you in late 2006 without any consultation at the last minute and under the radar, so to speak?
No, I don't think that would have been helpful.
Well, no, but it might have been relevant. So can you explain perhaps why you didn't think it fit to draw attention of those of that fact to those present?
I think at that time all we were focused on was the immediate response.
And does that answer also apply to why, as it appears, you didn't tell the Minister or those present that you had forgotten, as you told us, to issue a clarification on behalf of the department as to the meaning and the scope of that language, having learnt in July 2014 that it wasn't clear, at least to some sections of the industry?
No, I, as I say, at this point in time, we were focused on what can we do immediately, which was an enormous task. It transpired.
And did you tell any of those present that you had undertaken, in your own words, in March 2016, to change that very wording? And you'd undertaken so at a meeting of industry expert, at which you were present, having reached a consensus that it was poorly written, open to interpretation, and misleading.
I think the questions of what had or hadn't happened with approved document B was something that was raised very early. And as I recall, there was some officials were tasked with the job of looking back over what we had or hadn't said and done.
Did you tell anybody at the meeting that the lack of clarity in 12.7 of approved document B was a problem that you had indicated to industry professionals in March 2016 would be solved in the next edition of ADB, but which had been delayed?
No, that wouldn't have been helpful. This was a difficult enough task as it was.
So, do you disagree with my question that the matters I've just put to you were matters which would have been relevant and important for those at the meeting to know?
Not at this meeting, no. At this meeting, the question was, what do we do about this material? Are there other buildings? How do we ensure that no one else is at the same risk?
Was one of the reasons, or the reason why you mentioned none of the matters that I've just put to you, that you realised in the starkest possible terms that the catastrophic series of errors that you had made were on your watch, solely yours, and you didn't want to own up to them?
No.
Is there any other explanation?
Because we were focused on the immediate response.
And you knew very well that this wasn't a one-off, didn't you?
I was concerned there might be more. I was surprised how many there were when we eventually found out how many buildings were involved. I still find that hard to understand.
Why not tell those present at least that you were concerned there might be more?
This meeting was about an immediate response, and that's what we were focused on.
Very well. Let's go next to RBK 3015952. Now, Mr. Chairman, I'm sorry, before I go on, I do note the time. It's 25 to. I've probably got another 20 minutes or so left of main questions, which will take us to about 5 o'clock. And
then we'll have the usual.
Yes, I just want to make sure that everyone in the room is comfortable with that. I'm keen.
Well, I was going to find a moment to ask you that. Mr. Martin, you've heard what Mr. Millett said. If we're going to finish your evidence this afternoon, and I'm sure you'd like us to, it will mean sitting longer than usual, possibly, well, almost certainly beyond 5 o'clock. Is that going to be all right as far as you're concerned? And if we do that, would you like to have a short break now?
Clearly, I want to stay and finish my evidence, sir, and I am tired, but...
Well, we can take 5 minutes or so now.
Can we just take 5 minutes, please, sir?
Yeah, and I was also going to ask the shorthand writer, who was probably thinking what you're saying. It's been a long afternoon and her fingers are tired. So, Mr. Millett, I think we'll do that.
All right.
I know it's going to prolong things, but I think it's in everyone's interest that we don't press on too hard and too long for everyone. So we'll rise now and come back at 4:45, please. It's only 5 minutes, but I think it'll be worth taking.
Yes, sir.
Yes.
And same as before, please don't talk to anyone about your evidence while you're out of the room.
Yes, sir.
Yes. Can I also just make a plea for if those outside the inquiry are going to send follow-up questions in, that they make the most of the break as well, please.
Yes.
Because I can't entertain them if they come in a minute before I get back up to my feet.
That's a very fair point. Transcriber, is 5 minutes going to be enough for you? That's what we'll say. 4:45, please.
Yes, sir.
Right. Thank you, Mr. Millett. 4:45. Thank you. Would you ask Mr. Martin to come back in, please? All right, Mr. Martin, I'm sorry it was a short break, but I hope it's been helpful.
No, I'm grateful, sir. Thank you.
Ready to carry on?
Yes, sir.
Thank you. Yes,
Yes, Mr. Chairman, thank you. Can we please go to RBK 3014952? This is the letter dated 22nd of June 2017, sent by Melanie Dawes, the Permanent Secretary, to all local authority and housing association chief executives. Can we take it that you're familiar with this letter?
Yes.
Yes. Who was responsible for the technical input into it?
Probably me.
Can we look at Annex A, please, page 2? And in the first paragraph it says this: if it is determined that the insulation within an aluminium composite material, ACM, and there's a footnote 1, is unlikely to be compliant with the requirements of the current building regulations guidance, it is essential that you immediately, underlined in bold, implement the following interim mitigating measures to ensure the safety of residents pending replacement of the cladding. And the measures are then listed. And then if you look at the footnote at the bottom of page 2, it reads as follows: for the avoidance of doubt, the core, brackets filler, within an aluminium composite material, ACM, is an insulation material, stroke product, insulation product and or filler material, as referred to in paragraph 12.7, insulation materials, stroke products. In section 12, construction of external walls of approved document B, fire safety, volume 2, buildings other than dwelling houses. Brackets. The important point to note is that paragraph 12.7 does not just apply to thermal insulation within the wall construction, but applies to any element of the cladding system, including, therefore, the core of the ACM. Now, do you remember who wrote that footnote?
As I recall, I'm sorry, now looking at this document, I think this is the document which was drafted. There were about it was a subset of the group that had met on the Saturday, and we talked about all of these issues. So this is a sort of composite document drafted by several people.
Right. Let's see if we can explore that a little further. Can we go to CLG 3018973, please? Foot of page 2, email run on the 20th of June 2017. So 2 days before the letter was eventually sent. And if you look at page 2 at the bottom, there's an email. It says, all sorry about the delay, we had a bit of version control issue. However, I've now incorporated the amendments, including the input from NFCC as to what the FRSs are expected to do beyond being informed. We're not required to include advice on insulation in this document. Martin, that's, I think, Martin Ship, you raised a question about the link to Part B so that it's explicit. I'm content with Colin's common understanding of the terms of the body of the text. However, if you feel there's merit of a footnote, can you add it? Also, I know that Debbie's developing tests, so if you can agree on behalf of BRE, it would be really good if you could confirm your agreement with this final draft as a matter of urgency. Thanks very much, Ken Knight. Now, Martin there, I think, is Martin Ship. Yes?
I would think so.
Yes, if we go up to the next email in the chain, a little further up, page 2, we can see here is an email sent by Martin Ship a little bit later that morning. And he writes to you, Colin Todd, and Ken Knight, and others, and he says, Ken, here with a proposed footnote. I've tried to keep it as simple as possible. Regards, Martin. And the footnote as drafted by Ship is, let's look at it, HOM 3045123. And if we go to page 3, at the bottom in red, there is the footnote, and it ends, as you can see, with the words other than dwelling houses. It doesn't have the words in brackets referring to all elements of the external wall build-up, as we see in the final version. I just want you to note that. Now then, if we then go back to the email run, please, at CLG 3018973, page 1, foot of page 1. Here comes CST Todd, back to Martin Ship. back to Martin Shipp and Ken Knight. Ken, and it's copied to you, Martin's footnote is great to the extent that I think we could hammer it home even further, as people are confusing the insulation within the wall and the core within the ACM. Over the page, please. To that end, I've added a sentence to Martin's footnote and discussed it with Martin, who is happy. Hope this helps. As always, shout if you need any more. Best wishes, Colin. Can we agree on what I'm showing you, that the footnote to this letter was crafted by Martin Shipp and Colin Todd adding the last sentence in the brackets?
Apparently so. I don't remember the detail at the time.
No, okay. And then if you look at the next email up in the chain at page 1, sent by Ken Knight at 15:02, only to you, he says, Brian spoke to Colin on this. He says that there is an air of denial with that Part B applies to the cladding and DCLG have just got it wrong. It is, of course, not Colin's view. He thinks, therefore, that this is a good opportunity to hammer it home by expanding the footnote. And if you look at the response above that, you say to Ken Knight, thanks, Ken. You see that?
Yes.
Now, let's get back to the footnote that we've just looked at. That was at HOM 30451123, end of page. I'm so sorry. Bad reference. RBK 3015952. RBK 3015952, page 2, foot of page 2. There's the footnote. Let's look at it again, and particularly looking at the last sentence in the brackets there. Looking at that, do you accept that far from hammering home anything which had been previously known, this was the very first time that the department had confirmed in any formal manner that the words filler, material, etc. were to apply to the core of a composite panel?
In a formal sense, I think that's probably true, yes.
Yes. So this footnote was doing what you had, what had been called out for on the 2nd of July 2014 at the CWCT meeting, and which you had undertaken to do at the 17th of March 2016 CWCT meeting, but had not done.
And I honestly believe the Building Control Alliance guidance note had done that job. As has become evident, it hadn't.
My question was directed to you, though. Do you accept that this footnote was doing what you had been called out as requiring to do in July 2014, had undertaken to do in March 2016, but had not yet done?
That's true.
Yes, thank you. Now let's look at that final sentence, where it says, I'll read it again. The important point to note is that paragraph 12.7 does not just apply to thermal insulation within the wall construction, but applies to any element of the cladding system, including, therefore, the core of ACM. That's not right, is it?
It's not the interpretation that I'd come to. It's more in line, I guess, with the Building Control Alliance guidance note. I must have missed that at the time.
Yes. How come?
How did I miss it? I was probably really tired at that point, I think.
Well, it's lunchtime. Why were you tired?
I hadn't gone home.
Right. Just to be clear, you've given evidence that 12.7 in the 2006 version of ADB did not and was never intended to apply to any element of the cladding system, including the external facings. That's right, isn't it?
I'm sorry, I'm not sure if I agree with that, what you just said.
Well, when you
this is the difference between the surface and below the surface, which was the whole discussion about filler. And
yes. Yes.
You're saying that wasn't the intention?
Yes, you told us when you gave evidence about the amendment that you made to ADB in 2006 that the intention was to capture the core of the ACM, of a composite
Yes.
ACM panel,
Yes.
but not the surface.
Yes,
Yes.
sorry, it sounded like you were saying something different there. I apologise.
All right. So do you know how this false representation of the government's position about the intention behind 12.7 came to be included in this footnote, given that it does not reflect the content of the actual guidance as intended by you at the time?
It's a mistake on my part. I must have missed it.
Are you sure this wasn't a planned, deliberate and underhanded attempt by you and those around you to rewrite history in the light of the 71 deaths at Grenfell in order to protect the government's position after the event?
No.
You're sure about that?
Yes.
Let's then turn to the final event. On the Tuesday after the Grenfell Tower fire, that is to say, the 20th of June 2017, this very day, do you remember attending a meeting with Melanie Dawes, the then Permanent Secretary?
Yes.
Do you remember that the purpose of the meeting was for you to explain to her the relevant guidance in approved document B so that she understood it?
Yes.
Yeah. Do you remember what you told Melanie Dawes?
Not word for word, no.
Did you go through the text at 12.7 with her?
I think I did, yes.
Did you explain it to her?
Yes.
Do you remember what your explanation of that wording was?
It would have been along the lines of the same answer I've given you in this inquiry.
It was Melanie Dawes' evidence to the inquiry when she gave it on day 259 at page 153, lines 18 to 21, that during the meeting you acknowledged that because it referred to insulation, it might not be clear that it also applied to other materials. Is her recollection correct on that?
I can't remember.
Did you tell Melanie Dawes, as you've told us in this inquiry, that you weren't entirely happy with the text of 12.7 when it went in, or when the changes went in the latter part of 2006?
I'm not sure. I don't think I did.
Why didn't you?
There was a fixed amount of time, and I did my best to explain things as best I could. As I say, I can't be sure exactly the words I used.
Did you tell her that the particular wording had been introduced into approved document B in 2006 without any external scrutiny, without consultation, without a definition of filler material, at the last minute and under the radar?
No, I wouldn't have said that, and I'm not sure that's entirely fair. The text was drafted to some extent in response to a consultation. Documents changing after a consultation is not unusual.
Did you tell her that you didn't go back out to industry to ask them whether the word filler material was understood in the same way that you had intended it to be understood?
No.
No. Did you tell her, as I think you told us, that the change, which was a substantive one, had not been publicised in the normal way for fear, at least in part, that the department would be subjected to judicial review for introducing it without proper scrutiny?
No, because I don't think that wasn't my view then or now.
Did you give her any of the background to how this language had come into 12.7 and the problem that it was introduced to address?
I don't think I did.
Why is that?
There was a fixed amount of time available. It's the first time I'd ever spoken to a permanent secretary.
Yes, I can. And making allowances for that, did you not think it appropriate to give her just a little bit of your personal recollections about the background to 12.7, given the importance that it had now assumed in the deaths of 71 people in a single incident?
I briefed her as best I could at the time. I appreciate there may have been things that I could have said that I didn't.
She recalls, as she told us, that you did mention that you had been asked to clarify the meaning of the scope of 12.7. Do you remember telling her that?
I don't remember it at all, no.
Do you remember telling her that you had forgotten to do so?
Well, I don't think that's true.
Well, you told us it was. You told us that you'd forgotten to clarify it after the 2nd of July 2014.
No, the clarification after 2014, there was the Building Control Alliance guidance note, and after 2016, I'd agreed that I'd planned to amend approved document B, and at that time, I thought I was about to.
Did you tell her that you had been involved in a project, including large-scale testing in 2001, at the BRE involving ACM with a polyethylene cord panel, which showed that such panels caused a raging inferno during an external wall fire?
I wasn't aware of the details of the results of that test. I just had a general understanding of the outcome.
Did you tell her that in 1999 a parliamentary select committee had recommended a change to the relevant guidance such that all external wall materials should be entirely non-combustible or be proven through full-scale testing not to pose an unacceptable level of risk in terms of fire spread?
I doubt it.
Why?
I could have talked her through the entire history of the building regulations, I suppose, but I don't think that there'd have been time. I'd explained to her the provisions that were in place at the time.
Right. So you didn't think, therefore, to tell her that the recommendation made by the Select Committee had been rejected by the government of the day?
I may have done. I don't remember doing so, though.
Did you tell her that there'd been long-standing concerns about the adequacy of the national classifications, including Class 0, as a measure of fire performance?
No. I keep asking you questions. I'm sorry. Carry on.
Did you tell her that you'd received a number of warnings about cladding fires abroad, including in the UAE, in which ACM with a PE panel had caused rapid external fire spread?
I imagine I would have mentioned that there'd been similar problems in other countries.
And did you tell her that you'd been asked by your seniors in the department about those fires and whether those fires could happen here, and without giving guarantees said that they should not, in reliance on approved document B?
I doubt it.
Did you tell her you'd been involved in meetings and exchanges in the 4 years between 2013 and 2017, during which industry figures, including the BRE, NHBC, CWCT, and others, had explained that the guidance in ADB was not clear, open to interpretation, and misleading, particularly on the subject of whether it covered or didn't cover the combustible core of a panel such as an ACM panel?
I doubt that I did.
Why is that?
There wouldn't have been time.
And presumably the same answer would it to the question whether you told her that in early 2016 you'd been told by a reputable, or apparently reputable, cladding consultant that ACM PE panels were on many high-rise buildings in the UK, their use was increasing, and so far as he saw it, the current situation was of grave concern. Didn't tell her that either?
No.
Or that you'd underestimated the severity of the hazard, as you'd come to realise?
No, that's probably something, the realisation probably came after that, I imagine.
And you didn't tell her, I don't think, that you'd undertaken in March 2016 to change the very guidance 12.7, which was relevant to the use of these panels, which had been identified to you as poorly worded, open to misinterpretation and misleading. You didn't tell her that either?
I'm sorry, I thought you'd already asked me that question, and she said that I'd told her that I'd been asked to clarify it. But I honestly can't remember what I said, so maybe yes, maybe no.
Right. Nor did you tell her that in July 2016, only 11 months before, you had lent your tacit support to NHBC's guidance document to its building control officers, which expressly permitted the use of ACM with a PE core if it was Class B, in other words, not of limited combustibility, on buildings above 18 metres.
No, I wouldn't have mentioned that, because I was under the impression that they were panels that had an appropriate fire performance to get a BR 135 classification.
Now, I've provided, I'm afraid, rather a long list of questions of matters that I'm asking you, whether you drew to her attention. Are you able to agree that all of those matters that I've asked you about would have been highly pertinent and of fundamental and obvious importance for Melanie Dawes to know at the time?
I'm not sure they were at the time. I'm sure other people will think differently, but at that time I was asked to brief her on what the building regulations said and how they were intended to work, and I did that to the best of my ability.
Now, the catalogue of things that I've just put together and asked you about, can you help us understand why it was, and if I'm wrong, tell me, that you said nothing about these matters, not simply at this meeting, but at any other time?
Well, these are issues that I've discussed at various points with other people in the department.
So are you saying that everything I've just asked you about whether you told what you told Melanie Dawes are matters well known to Bob Leadsom or Richard Harrell?
At various points over the last 4 years, yes, I would have thought so.
Various points in piecemeal form, perhaps, but as a catalogue?
I haven't sat down and listed a catalogue, no.
When you put them all together, do you accept that they reveal a catalogue of failures, errors and omissions on your part, Mr. Martin?
I think to some extent, yes.
Mr. Chairman, I've come to the end of my prepared questions.
Yes.
Sorry it's taken longer than I had anticipated, and I'm grateful to Mr. Martin for his patience.
Yes, we'll have to have a short break at this point, won't we?
We will.
Mr. Martin, you may be aware of this, but when counsel gets to the end of his questions, we have to have a short break.
Yes, sir.
Partly to let him check that he's not left anything out, that you may think that's unlikely, and partly because other people are following the proceedings from other places and they may need to suggest questions that perhaps we should put to you. So we'll break now. We'll come back at 5:20. At that point, we'll see if there are any more questions that we need to ask you.
Yes, sir.
All right? So would you go to the usher then, please? Mr. Millett, I'm working on the basis that 10 minutes ought to be long enough,
It ought to be.
given the fact that we've had an earlier break.
I've had one or two through while I've been asking questions in the usual way, but I shall stop.
Well, if it turns out that you need a bit longer, you can ask the usher to let us know.
Yes, thank you.
Thank you. Would you ask Mr. Martin to come back in, please?
Thank you.
All right, Mr. Martin, we'll see if there are any more questions for you.
Yes, sir.
Thank you very much. Yes, Mr.
Mr.
Millett?
Chairman, there are no further questions. I've considered the questions that we have been asked with great care and on balance decided that we've covered a lot of ground.
Yes.
And we've had to cut our cloth correctly. And so there are no further questions I have for Mr. Martin other than one. And it's this, Mr. Martin, it's a question that we reserve for particular witnesses in this inquiry, and I'm quite sure that you know what it is. But looking back on your time, going back to 1999, the BRE, and looking back on the 7.5 days of evidence that we've covered together, is there anything that you would have done differently?
Yes, sir. I find it difficult to express how sorry I am for what's happened to the people of Grenfell Tower. Over the last few months, I've been looking through the evidence and the documents, and when you line them up in the way that we've done over the last 7 days, it became clear to me that there were a number of occasions where where I could have potentially prevented this happening. I think over time I'd become entrenched in a position where I was focused on what I could do to improve the approved document, and didn't realise just how big the problem was. I think there were times when perhaps I would have done. I think of the meeting in 2014 with the CWCT. If I'd been there in the second part of the meeting with Dr. Colwell there, I think between the two of us, perhaps we would have realised how severe the risk really was. And I think if I'd have realised that, I would have escalated the issue, and perhaps we could have done something to prevent what happened to the people of Grenfell Tower. What I will say is that the approach the successive governments had to regulation had an impact on the way we worked, the resources that we had available, and perhaps the mindset that we'd adopted as a team, and myself in particular. And I think as a result of that, I ended up being the single point of failure in the department. And I think that's why, when I missed that point, that's why I think we failed to stop this happening. For that's something I'm bitterly sorry. Thank you, sir.
Thank you very much.
Mr. Martin, thank you very much for that answer and for the entirety of your evidence. On behalf of the inquiry, we are extremely grateful to you for coming here and giving your assistance to us. So thank you very much.
Thank you.
And Mr. Martin, we're not going to let you go without saying a profound thank you for all the time and the evidence that you've given us. You've given evidence for longer than any other witness, and I think we all understand how difficult that's been for you at many points during the 7.5 days you've been in the witness box. I think all three of us would like you to know how helpful it's been to have heard your evidence, and we're very grateful to you for giving up so much time to come and talk to us. So thank you very much indeed. And now you're free to go.
Thank you, sir.
Thank you. Thank you, Mr. Millett. Well, that's certainly it for today.
Yes,
And tomorrow we have another witness.
we do. We have Lord Wharton of Yarm tomorrow morning at 10 o'clock. Can I just say to the panel and to the transcriber and to Ollie, who operates the documents, that I'm extremely grateful to all of you for sitting late on this occasion and finishing Mr. Martin's evidence. I know it's been a long day.
Yes,
but
well, I'd certainly
very
like
grateful.
to endorse your thanks, because we do trespass on the goodwill of those who keep us running in all respects. So thank you all very much indeed. 10 o'clock tomorrow then, please. Thank you.